Okay. Good afternoon. I'm going to call case number 2020-6666, Joy Walford versus Carl Mitchell. Counsel, please make your appearances announced ready for trial. We'll start with plaintiffs.
Your Honor, Megan Rose and Karina Sanchez for the plaintiff.
Defendants.
Your Honor, Enrique Santa Cruz and my co-counsel Sean O'Leary for the defendant, Mr. Mitchell.
Okay, plaintiffs, do you have any housekeeping matters?
Yes, Your Honor, we do. Plaintiff has a few housekeeping matters prior to the motion in limine. Before we proceed, we'd like to invoke Rule 615 of the constructive sequestration of all witnesses barring party representatives. The plaintiff in today's case, the party representative, will be Ms. Joy Walford.
Okay, so the rule is invoked. Defense, do you understand what that means?
Yes, Your Honor.
Okay, so the court is unaware of any. Is Mr. Mitchell here?
Yes, Your Honor. Mr. Mitchell will be a witness in today's case.
Okay, so there are no other party witnesses, if you will. So counsel are required to notify all their witnesses or potential witnesses that may testify today who are not covered by the rule, that they are to not watch the live stream or receive any kind of communications from anybody concerning the case. And you are to monitor that, since I have no way to know who you're going to call. And violation of that will be could be sanctions or contempt of court, which are included confinement or a money sanction. Counsel, do you understand?
Yes, Your Honor.
Plaintiff?
Yes, Your Honor.
Do you need time to contact your witnesses to tell them to turn off the live stream and not to tell anybody?
We've notified previously, Your Honor.
We have as well, Your Honor.
Okay, very good. What's your next housekeeping?
Your Honor, may we assume all witnesses have been pre-sworn?
Any objection from the defendant?
No objections, Your Honor.
Okay, so all witnesses are pre-sworn.
Your Honor, may we also assume that all screen sharing takes place outside of the presence of the jury until exhibits are admitted into evidence?
Any objection?
No objection, Your Honor.
So ordered. Next.
Your Honor, we would also like to take this time to request a brief recess after the plaintiff rests its case in chief and prior to closing arguments.
Any objection from the defendants?
No objection, Your Honor.
Okay, Ms. Sanchez, just remind the court.
Thank you, Your Honor. That completes housekeeping matters for the plaintiff.
Mr. Cruz or Mr. O'Leary?
Yes, Your Honor. May I proceed?
Yes.
Your Honor, as you know, pursuant to FRCP 51, the jury charge may be read prior to or after closing arguments. For the purposes of this trial, we ask that the jury charge be read prior to the closing arguments.
Any objection from the plaintiffs?
No objections, Your Honor.
Okay, Mr. Cruz, just remind me.
Yes, Your Honor. That concludes our housekeeping matters, Your Honor, and we do have a motion in limine.
Well, let's start with Ms. Sanchez. You have a motion in limine?
Yes, Your Honor. Thank you. May we proceed with the motion in limine?
Yes.
Your Honor, plaintiff has a motion in limine in 3 parts. The first part, Detective Hayes was previously suspended with pay. This was years ago and has nothing to do with today's events. His testimony to his suspension does not speak to his credibility to recount interactions and observations he has with both the plaintiff and the defendant. We ask that any line of questioning directed to this be precluded from today's trial.
Defendants, who's arguing this?
I am, Your Honor.
What's your response?
May I proceed?
Yes.
Your Honor, we believe that in order to get a full picture of who the credibility is of the testimony, we believe that that line of questioning should be allowed today.
Your Honor, may I respond?
Yes.
Detective Hayes was not placed on leave for any sort of improper protocol, improper actions, or anything that was related to any sort of breaking of the law. He was only placed on protocol because it was on leave, because it was the legal protocol for the police department based on the type of case that he was on.
Okay, I'm going to grant plaintiff's motion for leave, subpart 1. Mr. Cruz, Mr. O'Leary, if we need to get into this, you just first approach and we'll talk about it.
Yes, Your Honor.
What's your part 2?
Continue, Your Honor. Thank you. We anticipate also that defense will have their witness Dana Woods refer to Brad Pitt as the boyfriend of Miss Walford in order to diminish the plaintiff's character and her motherhood, basically. We would like to preclude this from the start.
Mr. Cruz?
Your Honor, We believe that in the line of questioning, we're allowed to say what their relationship is and what their relationship status is, Your Honor. So we believe that it is, again, towards the credibility and who they have been relating with.
Wait, what's the prejudice, Ms. Sanchez?
So we are referring to Miss Dana Woods, referring to Brad Pitt as Miss Walford's boyfriend. Not once has Miss Walford ever told Miss Dana Woods that Brad Pitt is her boyfriend. It would just be based on Miss Woods' speculation, not anything that she actually knows.
Okay, I will grant the motion eliminate, but we will reconsider this when there's testimony.
Thank you, Your Honor.
What's the next one?
Our third part of this motion is to preclude the witness Dana Woods from speaking to the opinions of her neighbors. This is hearsay as the neighbors are outside this courtroom today. We do, of course, concede to Ms. Woods speaking to her own thoughts and feelings and what she has observed herself.
Mr. Cruz?
Yes, Your Honor. Again, we believe that to get the full picture of what was going on, she discusses what she saw in the apartment, around the apartment that she lives in. So we believe this is necessary to get a full picture of what's going on in this case today.
Well, certainly she can testify to what's in her personal knowledge, and you won't elicit hearsay testimony. Correct, Mr. Cruz?
Yes, Your Honor.
Okay, so I don't think I have to grant number 3.
Thank you, Your Honor.
And just
Concludes our motion on limine.
if Mr. Cruz tries to do that, Ms. Sanchez, just object.
Absolutely.
Okay, defendants, do you have a motion limiting?
Yes, Your Honor. May I proceed?
Yes.
Your Honor, as you know, this case is about probable cause from a search warrant. Your Honor, we anticipate potential testimony from the plaintiff regarding a lie detector test. We ask that the testimony should be denied and struck from the record because we do not have an expert testifying on the results of the lie detector test. The results of the exam are only spoken of by the person that took the exam and not an expert in regards to the results of the exam.
Ms. Sanchez?
Yes, Your Honor. We're not speaking to the validity of the lie detector test. We're only speaking to what she was told was the result of the exam. Again, we're not trying to mislabel anybody nor the validity of the lie detector test.
Mr. Cruz?
Yes, Your Honor. Again, I don't think we should be able to take her by her word of what the result was. We should have an expert testifying what the result was.
The court agrees with you, Mr. Cruz. Court will grant your motion limiting number 1.
Thank you, Your Honor. And that concludes our motion to eliminate. We are ready to proceed with opening statements.
Wonderful. Okay, who's going to give the opening statements for the plaintiff?
That will be me, Your Honor.
Okay, Ms. Sanchez, you may proceed.
Thank you, Your Honor. Your Honor, opposing counsel, jury, my name is Karina Sanchez, and I, along with my co-counsel Megan Rose, represent the plaintiff in today's case. Detective Hayes reported that Mr. Carl Mitchell, today's defendant, stated the words, "Nail the bitch." Detective Hayes, who you will later hear from, heard Mr. Mitchell say those words directly to him when Detective Hayes suggested an alternative to the search warrant for Ms. Walford's apartment, the one that Mr. Mitchell was pursuing. You see, a police officer has the power to pursue a search warrant if they have probable cause. Nail the bitch. Jury, it is your job today to weigh the evidence laid out before you on the scale of justice. The more evidence in favor of one side, the more the scale of justice tips toward them. Plaintiff's role today is to prove by a preponderance of the evidence that there is more than a 50% likelihood that the defendant is liable for his actions or wrongdoings. The claim Ms. Walford has made against Mr. Mitchell is that he instituted a search warrant application without probable cause, and that Mr. Mitchell did so maliciously and with the intent of injuring the plaintiff. It's our job to prove to you that Mr. Mitchell had malicious intent and did not have probable cause. Malicious intent exists when there is an intentionally wrongful act committed against someone without any just cause. The elements of malicious intent are 1, intent, and 2, will. Detective Hayes is Carl Mitchell's superior and the first person Mr. Mitchell delivered his signed affidavit in pursuit of the search warrant to. Detective Hayes will share with you the blatant statements made by Mr. Mitchell. You will hear from the plaintiff herself, Joy Walford. She will express to you the nature of her relationship with Mr. Mitchell and how for her, this saga begins when Mr. Mitchell showed up to her apartment when he was not allowed to be there. Probable cause means an officer came to a reasonable conclusion that there is a fair probability that a person either committed or was committing a crime. It is important to note that probable cause only exists when not manufactured. It exists only when a power play is not afoot. Throughout the testimonies of the witnesses today, we will see the true nature of both Mr. Mitchell and Ms. Walford. We will be able to look at them individually rather than just an angry divorced couple. When considering the intent, will, and the power to invoke probable cause, consider the credibility of the plaintiff and the defendant. Jury, you are here to decide whether malicious intent existed and whether probable cause truly existed based on the evidence that we laid before you today. On the day of September 6, 2019, Ms. Walford was a young mom taking care of her sick daughter, a second grade school teacher, a young woman with a clean record. Her only flaw that day was her past marriage to Mr. Mitchell. Mr. Mitchell showed up at Ms. Walford's residence despite court orders explicitly stating that he was never to be there. Mr. Mitchell wanted to see his daughter, and Ms. Walford let him see their daughter to confirm that she was indeed sick. While there, he decided to take a quick bathroom break as he apparently couldn't hold it a second longer. Within about 6 hours, Ms. Walford was opening the door to Detective Hayes and a search warrant. In his plan to institute a search warrant for Ms. Walford's residence, Mr. Mitchell had to get approval from his superiors. Detective Hayes will speak to the hesitation upon approving the warrant. When Detective Hayes and police arrived at Ms. Walford's home, a news channel unit was already there. They had already found out who she was, where she worked, and why she was being arrested. Before even she knew, you will hear that this publicity eventually ended Ms. Walford's career and reputation. Our opposing counsel will likely try to prove that despite flaws present throughout his story, Mr. Mitchell had probable cause. They will likely push the narrative of an experienced officer and father simply focusing on what's right. Opposing counsel will likely try to diminish the credibility of Ms. Walford by criticizing her as a mother. Remember to consider the power dynamic here. My co-counsel and I must show you again that there is more than 50% chance that Mr. Mitchell is liable for the malicious prosecution of Ms. Walford without probable cause. Jury, at the end of this trial, you will be called upon to decide, did the actions of Carl Mitchell constitute malicious prosecution of Joy Walford without probable cause? If you decide yes, you found in favor of Ms. Joy Walford. And if you have determined that Carl Mitchell is liable for malicious prosecution without probable cause, then you have decided with the plaintiff. Throughout these testimonies, we urge you to ask yourself the question, is Mr. Mitchell actually telling the truth? Thank you.
Okay, thank you, Ms. Sanchez. Mr. Cruz, is this you?
May I proceed, Your Honor?
Yes.
Ladies and gentlemen of the jury, this is a case about a father who is an officer going to visit his daughter, whom he was concerned about, and reporting a crime that was being committed. My name is Enrique Santa Cruz, and along with my co-counsel, Sean O'Leary, we represent the defendant, Officer Carl Mitchell, today. As you heard from the opening statements of my opposing counsel, Ms. Walford wants you to believe that this was something with malice, jealousy, revenge, or abuse of power. But quite frankly, Officer Mitchell saw a crime being committed and with probable cause reported it, like any other officer would. Upon leaving the home of Ms. Walford, Officer Mitchell went to the police station, prepared a proposed search warrant that was then presented to 3 of his superiors, Detective Hayes, the chief, and Judge Kirk Crutcher, all of which authorized a search warrant. There is a process that must be followed by every police officer, and that is what Officer Mitchell did. Today, you're going to get to know Officer Mitchell. What you're going to learn is that he is a dedicated public servant that serves his community. Now, he sits here, accused of an offense he did not commit. The plaintiff is going to get up here today and try to spin you a story of revenge, retaliation, abuse of power. They want you to believe that my client acted outside of the boundaries of his work, when in reality, they're presenting nothing more than the typical actions that every officer takes when a crime is being committed. They also want you to know that he didn't have permission to be at the apartment because of a court order from the divorce. However, The defendant was going to the apartment to visit a sick daughter as he was not given 24-hour notice like the court demanded. But we aren't here to determine if the defendant is allowed to go visit his daughter or not. This is a case about having probable cause for a search warrant that Officer Mitchell executed. The evidence will show that in all of his years of service, there is no question that Officer Mitchell is professional and upholds the law of this country by following the rules and regulations of probable cause. The plaintiff does not have enough evidence to show that Officer Mitchell acted otherwise. The facts of this case will show you that Officer Mitchell behaved in a way that any rule-abiding police officer would, contrary to what they will tell you. On Friday, September 6, 2019, Officer Carl Mitchell, while off duty, went to Ms. Walford's home to check on his daughter, Angela. Ms. Walford told Officer Mitchell in the morning that Angela, his daughter, had a cold. The only reason that Mr. Mitchell went to the plaintiff's home was to check on his daughter. You will learn today that during the visit to the plaintiff's home in the morning, Officer Mitchell was received by Ms. Walford, who was drinking. As Officer Mitchell walked towards his daughter, the living room had 3 guests in sleeping bags. After confirming that his daughter was sick, Officer Mitchell went to use the plaintiff's bathroom and saw marijuana. As any police officer would, Officer Mitchell went straight to the police station and prepared a search warrant. The evidence will show that Officer Mitchell had probable cause to proceed with this warrant. The evidence will show that there was marijuana at the plaintiff's home and she was arrested for the misdemeanor. What you're going to learn today is that there was probable cause for a search warrant and there was no revenge, no retaliation, no abuse of power like the plaintiff alleges. Our client was doing nothing more than following the standard procedures of his job. We're going to bring 2 witnesses today, Officer Carl Mitchell and Dana Woods, to tell you about what happened on Friday, September 6, 2019. Officer Carl Mitchell is going to tell you about his relationship with the plaintiff, what he saw at the apartment that day, and what he did after he left the apartment. Dana Woods, Ms. Walford's neighbor, will testify to Ms. Walford's lifestyle. What you're going to learn is why Officer Mitchell had probable cause for a search warrant. Probable cause is defined as a reasonable ground of suspicion supported by circumstances sufficiently strong in themselves to warrant a cautious, reasonable man in the belief that the person that's being accused is guilty of the offense charged. In short, ladies and gentlemen, we expect all of the evidence presented to you today will show that Officer Mitchell had a probable cause to institute a criminal proceeding against Ms. Walford. For the plaintiff's claim to prevail, the plaintiff must prove by preponderance of the evidence that Officer Mitchell maliciously and without probable cause instituted a criminal proceeding against Ms. Walford. However, if there is probable cause, the plaintiff's claim cannot prevail. Members of the jury, this is a civil case, and the plaintiff must prove her case by preponderance of the evidence. At the end of trial today, we ask you to find the only conclusion that the evidence supports and that justice demands. The defendant is not liable. I am confident by the end of this trial, you will find Officer Mitchell not liable. Nothing further, Your Honor.
Okay, thank you, Mr. Cruz. Plaintiffs, you may call your first witness.
Thank you, Your Honor. Jury, my name is Megan Rose. I, along with Ms. Sanchez, will be representing the plaintiff, Joy Walford. Plaintiff calls Ms. Joy Walford to the stand.
Okay, Ms. Walford, you there?
Hi.
Okay, you are already sworn in. Do you understand?
Yes. Thank you.
Okay. You may proceed, Ms. Rose.
Thank you, Your Honor. Ms. Walford, please introduce yourself to the jury.
Hi, my name is Joy Walford.
Ms. Walford, why are you here today?
My ex-husband came to my apartment when he wasn't supposed to. He went into my bathroom despite my refusal, and hours later, I was being arrested for marijuana that was not mine. The affidavit for the search warrant had his name on it. I'm not surprised he manipulated his position with the police department to get me arrested. Because of what I believe to be a plot against me, I've lost my job, I've decreased wages, and now I have to live with the fact that people think I'm some kind of druggie. I'm rebuilding a life that was unfairly stolen out from under me.
Sorry, hold on, Ms. Walford. Mr. O'Leary?
Objection narrative.
Your Honor, may I respond?
Yes.
Your Honor, my witness is laying the foundation for why she's here today. She hasn't spoken out of turn. She's been only giving her opinion, and she's just stating very upfrontly why she's here.
For a very long time. I'm going to sustain the objection.
Okay.
Ms. Walford, please listen to the question and answer only the question that is asked.
Okay.
You may proceed.
Yes, Your Honor. Ms. Walford, out of respect for the court and the jury, there is a discrepancy that we need to clear up for the jury. What date was your daughter born on?
March 13th, 2017.
And Ms. Walford, do you remember the deposition that you gave in this case?
Yes.
Do you remember what year you stated that your daughter was born during that deposition?
Yes, I was thinking about another date, and I said 2018. That's wrong. She was born in 2017.
Why do you think that you made this mistake? It's a pretty big mistake. Why do you think you made it?
This case has been extremely stressful for me. I think I was just nervous because I've never been in a trial or anything before. My record is clean.
Ms. Walford, can you tell me a little bit more about your daughter?
Her name is Angela. She is 4 years old, and she's everything to me.
And who is Angela's father?
Carl Mitchell.
Are you married to Mr. Mitchell?
No, we are divorced a little over 2 years now. We got divorced in July of 2018.
And what do you do for a living?
I'm a store clerk at a 7-Eleven store.
Do you like your job?
No, not at all. I don't make near as much as I did when I was teaching.
And what grade were you teaching prior to working at 7-Eleven?
Second grade.
Did you like that job?
Yes, very much.
Why did you stop teaching?
I was fired by the school board after being arrested for the possession of marijuana.
What happened with that charge?
It was dismissed without a trial, but it didn't matter. It was too late for me.
What do you mean by too late for you?
I was fired by the school board on the as a result of the publicity surrounding the charge.
Speculation.
Your Honor, may I respond?
Yes.
This is not speculation, and you will see, as I will soon prove, that there is a direct link between the publicity of the arrest and her termination.
I'll overrule it.
Ms. Walford, you were saying, excuse me, Ms. Walford, did you wanted to say what you got to say? What you meant by being too late?
Can you re-ask the question? I'm sorry.
Sure. Ms. Walford, what did you mean by it was too late?
Just that the reason I was fired was a result of the publicity around the charge.
And just as briefly as possible, why did the school board find out about the charge?
The day I got arrested and was walking out of my house or apartment, there was an entire Channel 8 news team outside that already knew the details about my arrest.
Okay.
Speculation.
Mr. O'Leary, if you're going to object, do so louder so we can hear you. And when we do hear that he objects, Ms. Walford, would you stop and we can consider his objection?
Yes,
So
Your
what
Honor.
was your objection?
I said speculation. May I explain myself?
Yes.
She was speculating to what the Channel 8 news station had already known. We can't substantiate that by any means.
Ms.
Your Honor,
Rose?
may I respond? Yes. As my witness is about to state, they did in fact know who she was.
So why don't you ask that question?
Yes, Your Honor. And thank you for allowing me to proceed. What did the news channel say to you?
One of them had a microphone and shoved it in my face. They already knew of my arrest, and they mentioned that I was a teacher, which was mortifying. I was in tears. I didn't know how they knew the information.
And what was the school board's reasoning for your termination?
They said that the news coverage surrounding the arrest was too much publicity for the district.
Okay. Your Honor, at this time, I would like to direct the witness and opposing counsel, not the jury quite yet, to open their case file to page 41, pre-marked as Exhibit C.
Okay.
Ms. Walford, do you recognize Exhibit C?
Yes.
Without describing its detail, what is Exhibit C?
My letter of termination from the school board.
Okay. Your Honor, at this time, I move to admit pre-marked Exhibit C into evidence tendered to opposing counsel, and to publish to the jury via share screen function.
Mr. O'Leary?
No objections.
Okay, Exhibit C is entered.
Thank you, Your Honor. Am I sharing my screen?
Yes.
Ms. Walford, is this a depiction of the termination letter you've just mentioned from the Travis County School Board?
Yes.
Ms. Walford, can you please read the first sentence of this letter and the first sentence only?
Based upon your arrest by the Austin Police Department on September 6, 2019, and the county-wide publicity concerning this arrest, this is to notify you that by unanimous vote of the school board, your employment with the Travis County school system has been terminated immediately.
Thank you, Ms. Walford. I'm going to stop sharing my screen. Have I stopped sharing screen?
Yes.
Thank you. Ms. Walford, in your opinion, who do you believe put this marijuana there in your bathroom?
Carl Mitchell.
When did you first meet Mr. Mitchell?
When I was in college.
And just briefly, what was the marriage like?
It was rough just because we fought a lot. I'm not surprised that it would go this far after just all of that. You would think it would be me being the mother of his children would mean something, but he never wanted kids, so I don't know.
Okay. And how did Mr. Mitchell react when you told him that you were pregnant?
He was upset. We had talked about not having kids at that point, but it just kind of happened. At that point, neither of us were ready to be a parent.
Understandable. And how do you feel about being a parent now?
Angela is the best thing that ever happened to me. I work and do everything I can to provide for her.
Were you separated before your divorce with Mr. Mitchell was finalized?
Yes, for about 8 months.
And after your divorce, were things easier?
Yeah, after we had got to a point where we did drop-offs and pickups at the police station, and neither of us paid alimony. Sorry.
Okay. Your Honor, at this time, I would like to direct the witness and opposing counsel to open their case file to page 35, pre-marked as Exhibit B.
Okay,
Ms. Walford, do you recognize Exhibit B?
Yes,
Without describing its detail, what is Exhibit B?
my divorce papers.
Is this document a fair and accurate representation of your original and finalized divorce agreement with Mr. Mitchell?
Yes.
Your Honor, at this time, I move to admit pre-marked Exhibit B into evidence, tendered to opposing counsel, and published to the jury via share screen function.
Mr. O'Leary?
No objection.
Okay, Exhibit B is admitted.
Thank you, Your Honor. Ms. Walford, can you see my screen?
Yes.
Ms. Walford, I'm going to turn to page 5 and have you read a portion of this, okay?
Okay.
Ms. Walford, can you please read Part D? It says alimony.
Mm-hmm. The whole section there? On D?
Yes, just the one sentence.
Sorry. Because this marriage lasted only 4 years and the wife has the education to regain a salary level equal to the salary of the husband, the court awards no alimony to either party.
Thank you, Ms. Walford. I'm also going to ask you to read another section. This one is not as straightforward. So this falls under Section E, child custody and support, and it's going to fall under Section I. Section I begins here, and I'm going to scroll to page 5. Could you please read the first full sentence at the top of page 5 for me? It starts with the words, the husband.
Yeah. The husband is directed to never appear at the residence of the wife, and the wife is directed to never appear at the residence of the husband.
And what does the sentence after that say?
Severe sanctions will be considered by this court if either party violates this provision.
Okay, thank you, Ms. Walford. I'm going to stop sharing my screen now. Have I stopped sharing my screen?
Yes.
Yes, ma'am.
Thank you. Ms. Walford, why do you believe Mr. Mitchell came to your apartment despite the divorce papers?
I'm not totally sure. I mean, he called me that morning because it was his weekend to have Angela. I took the opportunity to ask him if we could switch weekends so that I could keep an eye on her, but I never made it seem like an emergency or I needed him. He also asked me if Angela was in a state of he also didn't ask me if Angela was in a state of emergency. On the phone, he never said he didn't think she was sick.
Okay, and what happened after the call?
He showed up at my place. I told him he wasn't supposed to be there, but he wouldn't leave until he could see our daughter.
And did you let him into your apartment?
Yes.
Why did you let him into your apartment?
He was refusing to leave, and I was scared that if I called the cops on him, he wouldn't care because he is one of them.
What happened next?
He asked to go to the bathroom, and even though I said no, he still went in anyways.
What happened after he came out?
He agreed to leave Angela with me and to swap custody for next weekend.
And what happened after Mr. Mitchell left?
Well, later that afternoon, Detective Hayes and 2 other officers came to my apartment and said that they had a warrant to search the place.
And how did you respond?
I asked to see the warrant, and I read through it and saw Carl's name on the affidavit, and immediately my blood ran cold.
Why?
I knew that my ex-husband had reached a new low.
And what happened next?
The officers and Detective Hayes began searching the residence.
Ms. Walford, had you been drinking alcohol that day?
By the time at that point of the day when Detective Hayes arrived, it was 4 or 5-ish in the afternoon. I had had 1 beer and just opened a second.
Okay. And Ms. Walford, if there had ever been an emergency or a need to go to the hospital, what would you have done?
Well, I could have called 911, get an ambulance. There's Uber, Lyft, there's a lot of options.
Thanks, Ms. Walford. What happened after Detective Hayes began searching?
The officers found marijuana in my bathroom.
And what was your reaction?
I had a bad, skeptical feeling, to be honest. Carl was in my bathroom earlier that day, despite me refusing to let him in and my overall just like not wanting him to be there. And now his name was on this affidavit. It just seems suspicious.
Okay. And what's his name?
Carl Mitchell, I'm sorry.
No, it's fine. What happened after that?
Detective Hayes, I think he tried to make this experience as painless as possible. He let me call a babysitter for Angela, and then we left. But then that's when I saw the news team outside.
And this is the same news team you mentioned previously?
Yeah, and like I said before, they knew who I was, and that was a teacher. And the reason I was being arrested was stressful.
And what happened after you got to the police station?
The booking process was pretty short. I was fingerprinted, and then the detective drove me home and left.
And what happened after all of this?
Well, the next Tuesday is when I received notification from the school board that I had lost my job because of the publicity and everything.
And after your charges were dropped, did you try to teach somewhere else?
I mean, yes, but I couldn't find a job anywhere.
Why is that?
Because of the arrest, I can no longer teach in the city of Austin or in the state of Lone Star.
Ms. Walford, does the marijuana found in the apartment belong to you?
No, I would never allow drugs in my apartment.
Thank you, Ms. Walford. Plaintiff passes the witness.
Okay, Mr. O'Leary?
May I proceed?
Yes.
All right, Ms. Walford. On September 6th, 2019, can you say with certainty there were or were not any guests there visiting you at the apartment that day?
There may have been my brother.
So your brother may have been visiting you, nobody else?
I'm not sure exactly. There was so much going on that.
You mentioned earlier you were drinking that day.
I had 1 drink.
So you remember exactly how much you drank that day?
Objection asked and answered.
Answer the question if you can.
Yeah, I remember that specifically just because, I don't know, it was just a point of relevance, I guess.
So you remember that, and you, in the direct examination, you remember a lot. You don't remember if there were any guests visiting you at that apartment that day.
Objection asked and answered. She's already given her opinion on this.
Move on, Mr. O'Leary.
Do your brother and his friends come over?
Can you repeat that? I'm sorry.
Do your brother and your friend and his friends come over?
Objection, relevance.
Mr. O'Leary?
Can you respond?
Yes, what's your response?
This is directly relevant to the fact that there were people there that day. We will have other witnesses testify to that. And so I see how having brothers and friends come over regularly and she's not aware if they're there or not, I think is very relevant.
I'll overrule. The objection's overruled. Ask it again, Mr. O'Leary.
Your brother and his friends come over,
Yeah, I have guests sometimes at my house.
and Officer Mitchell came to the house at 11 a.m., correct?
Yeah, Carl came. That's when he arrived.
And then Detective Hayes came to the house at 4:30.
Around that time, yes.
Brad Pitt is your really close friend,
We're friends, yeah.
and he visits often.
Sometimes.
Brad Pitt came to this house on this particular day.
No, not that I recall.
You seem a little unsure. I can move on. In the bathroom, Detective Hayes found marijuana, correct?
Correct.
Did the marijuana belong to you?
No,
Did the marijuana belong to your brother?
no,
Did the marijuana belong to your brother's friends?
no,
Did the marijuana belong to Brad Pitt?
no.
Objection. You're asking her to speculate who it belonged to and she doesn't know.
You opened that door when you asked her if it belonged to the detective. So overruled.
Yes, Your Honor.
So let's rewind a little bit. Angela was sick that day, correct?
Yes.
And you allowed Officer Mitchell to see Angela that day.
I mean, I didn't really have a choice. He came in and I asked him to leave, so he saw her.
And you stayed with him while he saw her?
Yes. Yes.
He was satisfied when he saw Angela, correct?
He seemed to be. I don't know.
So then later in that day, Detective Hayes came to the apartment with a search warrant, and he mentioned you had been drinking. Is that true?
Can you repeat the question? I'm sorry.
Detective Hayes was aware that you were drinking as well.
I guess so. I mean, it wasn't a secret. I had a drink open when he arrived. I'd had one drink.
I apologize. Do you agree with me, yes or no, that it's inappropriate to drink while your child is sick?
No.
Going back a little, you and Officer Mitchell talked that morning, correct?
Yes.
And you told him, I'm sorry, before his visit.
Yes, on the phone.
And you told him that she was sick then at that time.
Yes, I'd asked to keep her for the weekend.
It was Officer Mitchell's weekend to have Angela, though.
Yes.
And did you or did you not also ask that morning to keep Angela?
Yes.
At this time, I would like to approach the witness with Exhibit B. I believe it was already shared with the jury and published. So if my partner, Mr. Santa Cruz, could pull it up on the screen share.
Okay.
Mr. Santa Cruz, one more page. And there you go. It's subsection J here. This was after the section you talked about your husband being there despite the previous section. It says here, if a child is ill, the residential parent should give a 24-hour notice if possible, so alternative plans can be made. Are you the residential parent?
Yes.
And you attempted to keep your daughter despite not giving him 24-hour notice of cancellation. Is that correct?
Well, it says if possible. I made the determination that day that she was sick, and so I thought it would be best at that point to make that call. 24 hours prior, it wasn't a concern for me.
Mr. Santa Cruz, you can stop the screen share. In the past, you have said that you intentionally retaliated against your husband to upset him, correct?
Yeah, we were both young.
That morning, Officer Mitchell was upset. The morning of his visitation, Officer Mitchell, was he upset?
Oh, I don't know. I couldn't tell. It's hard I don't know.
So he
You
came.
have to ask him.
You don't know if he was not upset.
I don't know if he was. He's just kind of a loud and hostile person, so I don't know if he was upset or that's kind of just him.
And did you give him 24-hour notice?
No, like I said before, 24 hours previous, I didn't think it was needed for me to keep her, but I made the call. Just, you know how things happen. Kids are so unpredictable.
Understand. We'll move away from that relationship from Officer Mitchell, but I would like to talk about another relationship. Do you know a man named Charles Marcos?
Yes.
And did you or did you not have a romantic relationship with Charles?
We went on a few dates.
Who does Charles work for?
He's the state attorney office.
Is it true, yes or no, that Charles asked Officer Mitchell to take a lie detector test?
Yes, he refused though.
And who helped you drop your charges?
I'm not sure. I mean, he's who got me to take the lie detector test, but I'm not aware of any.
So let me say this a little more clearly. Did you not say in your deposition that Charles talked your boss into entering the null prosecute and dropping the criminal charges?
Yes, but I misunderstood. I was not privy to those conversations.
Okay. Did you manipulate Charles Marcos into helping you drop those charges?
Not at all.
But you've had a romantic relationship beforehand, correct?
We went on a few dates.
And he dropped the charge. And he got the boss to drop the charges?
Objection, speculation. She does not know further than that.
May I respond?
Yes.
I believe she said earlier, she confirmed that she said that Charles Marcus talked to the boss to drop the no prosecute or submit the no prosecute.
If it's in her personal knowledge, she can answer. Why don't you rephrase the question?
Did Charles Marcus get his boss to drop the charges?
Yes, they were dropped by the office. I don't know the details of the discussion.
Okay. I pass the witness.
Ms. Rose, read
Yes, sir. Ms. Walford, it is correct that I did bring up, that your brother's friends, but to clarify, you've never seen them consume drugs, correct?
No, never.
And one more time, who is Brad Pitt?
He's a longtime friend.
And Ms. Walford, you told State Attorney Mr. Marcos what happened with your arrest, correct?
Yes.
Why?
Like I said, we'd went on a few dates. We had built a friendship. I know he's an attorney. I'm not an attorney or a teacher. I don't know anything about the law. I thought he could help me understand what was happening.
And to clarify, the state of Lone Star voluntarily dropped your charges, not Mr. Marcos, correct?
Yeah, yes.
Were you dating Mr. Marcos at the time the charges were dropped?
No,
And have you dated him since the charges were dropped?
no,
Ms. Walford, is Mr. Mitchell permitted to appear at your apartment under any circumstance per your divorce papers?
no.
Ms. Walford, are there exceptions to the requirement that either you or Mr. Mitchell call the other parent with a 24-hour notice prior to adjusting the custody schedule?
Yes, if possible, which I did when I notified him when I made that decision, split-second decision.
Ms. Walford, would you ever allow drugs in your apartment?
Never.
Your Honor, no further questions. May this witness step down.
You may sit down, Ms. Walford. Okay, plaintiffs, you want to call your next witness?
Plaintiff calls Detective Jordan Hayes to the stand.
Detective Hayes, how are you?
Good, Your Honor. How are you?
I'm well. You are pre-sworn, you understand?
Yes, Your Honor.
Okay, Ms. Sanchez, you may proceed.
Thank you, Your Honor. Detective Hayes, can you please introduce yourself to the jury?
Yes, my name is Jordan Hayes.
And it might be a little obvious because I'm calling you Detective Hayes, but can you tell us about your job and what it is?
Yes, I am a detective at the City of Austin Police Department.
And can you briefly describe your work history and tell us how you got here?
Yes, after a BA in criminology, I was a police officer for about 8 years, and then I was promoted to detective, and I've been a detective for about almost 7 years.
And were you a police officer for the City of Austin?
Yes.
And can you tell me your experience as a police officer for the City of Austin, Detective Hayes?
Yes, with over 10 years of experience, I have developed a sixth sense for the truth. I call it my smell test.
What is your smell test?
Basically, all officers have this. It's where when facts are brought to your attention and they don't sit well with you, or it feels that something's right, you assess your situation and just proceed with caution.
And what is your opinion of Mr. Mitchell, the defendant here today?
He's a bit of a loose cannon. He always talks about his divorce and how the judge screwed him and how his ex-wife is a poor mother, as well as how he wants custody of his kid.
And do you work with Mr. Mitchell a lot to know about all of this?
No, I don't work with him daily, but I have heard his ravings a dozen times.
Why did Mr. Mitchell come to you on Friday, September 6, 2019?
Mitchell came to my office with a typed affidavit and a proposed search warrant, and he wanted me to authorize it since he'd been to the apartment of his ex-wife. He said he had seen his ex-wife smoking marijuana and in front of their daughter, and also that he had seen a large amount of marijuana there.
And what did he want from the detective division in particular?
He wanted to get the warrant signed and executed.
Who else was in your office when Mr. Mitchell told you this?
Nobody. I have my own office.
And how did you respond?
I asked Mitchell if he was sure. I suggested the possibility of child welfare instead before going through a full police investigation.
And what did Mr. Mitchell say to you in response?
He said, "Nailed a bitch."
How did you proceed?
I took the affidavit and the proposed warrant to the chief.
Is it common for you to proceed this way?
No, it's not.
Why then did you proceed this way that day?
I knew Mitchell had bad blood between him and his ex-wife and wanted custody of his kid.
Did the affidavit and proposed search warrant pass your smell test that we discussed earlier?
No, it did not.
What happened when you met with the chief?
The chief read through the paperwork and listened to me fill him in on the rocky background between Mitchell and his ex-wife, and then called Mitchell in to question him thoroughly. And then after he did that, he authorized me to find a judge and then gave a stern warning to Mitchell.
Were you in the chief's office at this time?
Yes, I was.
Who else was in the chief's office?
It was nobody besides me, Mitchell, and the chief.
What did the chief warn Mitchell about?
He told Mitchell that if he lied about anything in the affidavit or the warrant, that the chief would personally see that he would never work again in law enforcement.
Detective Hayes, why did you facilitate the affidavit and search warrant when you said it didn't really pass your smell test?
My job is to bring any concerns to the chief of police for him to decide. I don't make my own protocols. I follow what the law demands of me. I voice my concerns. The rest is out of my hands. And so the chief made his decision.
And Detective Hayes, before we proceed, I think it's important that I ask you why, in your opinion, if both you and the chief were hesitant to the point where the chief had to ask Mr. Mitchell questions and give him a warning, why do you believe nobody completely blocked the execution of the affidavit and the search warrant?
Objection, speculation.
Your Honor, may I respond?
Yes.
I'm speaking to Mr. Detective Hayes, who was one of the people that did facilitate this. He's talking about the situation at hand, and it is relevant to why we're here today.
What's the question again?
Would you like me to repeat it, Your Honor?
That's what I'm asking. Yes.
Thank you. Detective Hayes, before we proceed, I think it's important that I ask you why, in your opinion, as a member of the police force and detective agency for the city of Austin, when both you and the chief were hesitant, why do you believe nobody blocked the execution of the affidavit and the search warrant?
Was
May
it-
I answer, Your Honor?
Is it the same objection, Mr. Sanchez? Mr. Cruz?
Yes, Your Honor, speculation.
Overruled. On speculation.
Thank you. Detective Hayes, would you like me to repeat the question, or do you want to answer?
Do you mind repeating it one more time?
Absolutely. Before we proceed, I want to ask you why, in your opinion, if both you and the chief were hesitant about Mr. Mitchell, why do you believe nobody blocked the execution of the affidavit and the search warrant completely?
Everything Mr. Mitchell told us and typed out on the paperwork pointed to probable cause. At that point, we can only look to the facts that we were told by a police officer.
And what happened next?
I took Mitchell to a judge to get the warrant issued. I told Mitchell to get lost and not to be anywhere near his ex-wife's residence. And then I took a detective and another officer to accompany me to search the residence.
And Detective Hayes, who signed the affidavit?
The judge.
Did he also sign the search warrant?
Yes.
Did you remain with the other detective and the 2 officers from the time that you got the search warrant until you reached the residence?
Yes, we all went together. It's protocol.
What time do you think you arrived at the residence?
Around 4:30.
Was there anything odd when you arrived to search the apartment?
Yes, there was a Channel 8 news van there.
Why did the television unit know to be at Miss Walford's apartment?
Objection,
I'm-
speculation.
I can rephrase, Your Honor.
Yeah, it's sustained. Okay,
Absolutely.
phrase.
Absolutely. Detective Hayes, do you know why the television unit knew to be at Miss Walford's apartment?
I'm not sure.
Who knew that there was a search warrant about to be executed?
Only Mitchell, the chief, me, the judge, and then the 2 officers helping me.
Was there police radio traffic about the warrant or the address or anything that was really public?
No.
In your opinion, what was the only way that the news channel could have known?
If either me, Mitchell, the chief, the judge, or the 2 officers had said something.
Did you tell the news unit?
No.
To your knowledge, did the chief, the judge, or the 2 officers helping you tell anybody about the mobile television unit? Tell anybody about the mobile television unit, excuse me?
Sorry.
Mr. Cruz?
Objection for speculation, Your Honor.
Your Honor, may I respond?
Well, you're asking her personal knowledge, so if you know.
Thank you. I'm going to repeat the question, Detective Hayes. To your knowledge, did the chief, the judge, or the 2 officers helping you tell anybody about the search warrant that day?
No, not that I know of.
What happened when you knocked on Miss Walford's door?
I showed her the warrant and advised that we would have to search her apartment.
Did Miss Walford resist?
No, she invited us in and asked to see the warrant. Once she saw that Carl Mitchell's name was on it, she said, "That son of a bitch, she will never give up."
Did Miss Walford mention anything to you about that day that might prompt that statement?
She told us that Mitchell had been there that morning and she had to order him out.
Did she tell you anything else about that day?
She said that if there had been any dope in the apartment, you could be sure that Mitchell had planted it.
To your knowledge and your experience as a uniformed police officer and detective, is it possible that somebody could plant marijuana in another's home?
Objection,
Yes.
leading.
Rephrase.
Yes, Your Honor. In your experience as a uniformed police officer and detective, has somebody ever planted marijuana in another's home?
Yes.
Could you describe Miss Walford's appearance that day?
She was glassy-eyed and smelled like alcohol.
Detective Hayes, did you ever say that Miss Walford was drunk or intoxicated to anybody?
No, never.
Did you ever feel the need to have her blood alcohol level checked?
No, that would have been completely unwarranted.
Was she slurring her speech or showing any motor deficits or basically acting in any manner indicative of her being drunk?
Objection, leading.
Rephrase.
Yes, Your Honor. Was she acting in any manner indicative of her being drunk?
No, she was not slurring and she had normal balance in conversation.
Were you concerned about her ability to care for her child or act in a safe manner?
No.
Objection, leading.
Okay, Detective Hayes, when you hear Mr. Cruz, just stop speaking if you will. It's hard on Zoom. I know it's hard on Zoom. Mr. Cruz, what was your objection?
Leading, Your Honor.
Your Honor, may I respond?
Sure.
Detective Hayes did say that she smelled slightly of alcohol, and because this is a case that does merit a lot of importance upon Ms. Walford as just a decent human being, we would like to point out that she wasn't acting in an unsafe manner.
Well, the objection was just leading, so just ask it in non-leading.
Oh, okay. Yes, Your Honor. All right. May I
Right.
continue?
That was your objection, Mr. Cruz, right?
Yes, Your Honor, leading.
Yeah, so just ask in a non-leading way.
Absolutely, Your Honor. Detective Hayes, was there any concern when you arrived at the home?
No, she seemed normal. She just smelled like alcohol. I didn't have any concern about her ability to care for her child.
In your time as a police officer, whenever you come across people perhaps out for the night, because everybody does that bar duty, have you ever seen anybody just exhausted or post-crying who also looked glassy-eyed?
Objection, leading.
May I respond, Your Honor?
Well, it's overruled.
Thank
answer
you.
the question, Detective Hayes.
Absolutely. I'll ask again, Detective Hayes. In your experience as a police officer, I mean, you come across people all the time. That's your entire job. Have you ever seen somebody exhausted or post-crying who could also be described as glassy-eyed?
Yes.
So could it be possible that she was glassy-eyed, as you described, from a different reason besides alcohol consumption?
Yes.
Did you proceed to search the apartment?
Yes.
And did you locate any contraband?
Yes.
Where?
And a round talcum powder contained in the top drawer of the vanity in the bathroom.
And what was in that little container?
It was a baggie containing marijuana.
Did you ever find out how much marijuana was in that baggie?
When it was measured later, it was 19 grams.
Did this match Mr. Mitchell's description of a large amount of marijuana from your meeting at around 2 p.m.?
No, this wasn't a very large amount.
Your Honor, at this time, I would like to direct the witness and opposing counsel to open their case file to page 30, pre-marked as Exhibit A.
Okay,
Would you like me to give everybody some time, or may I proceed?
I think you can proceed.
Thank you, Your Honor. Detective Hayes, do you recognize Exhibit A?
Yes.
Without describing its detail, what is Exhibit A?
It is an affidavit and application for search warrant.
Your Honor, at this time, I move to admit pre-marked Exhibit A into evidence tendered to opposing counsel and published to the jury via share screen function.
Any objection?
Objection, Your Honor.
Exhibit A is admitted.
Thank you. All right. Am I sharing my screen?
Yes.
Perfect. All right. And let me scroll. Can you see me highlighting the screen, Detective Hayes?
Yes.
Can you read the words that I've highlighted for everybody here today?
A client entered the bathroom in the apartment and saw in a cabinet an object shaped like a brick, which your affiant determined was pressed marijuana and weighed approximately 2 pounds. As a police officer, affiant has seen marijuana hundreds of times during investigations.
Thank you, Detective Hayes. I'll stop sharing my screen. What did Mr. Mitchell say when he came to speak to you in your office earlier that day?
He said he had seen Joy smoking and had seen a large amount of marijuana.
Thank you. Detective Hayes, did you know that 2 pounds is about 907 grams?
No, I didn't know that.
Would you say, in your opinion, that 907 grams is a much larger amount than 19 grams?
Seems like it.
In your experience as a police officer within the City of Austin Police Department, would an experienced police officer that has gone through the police training there be likely to accidentally think something that is actually 19 grams is 907 grams?
Objection, leading.
Sustain that one.
Thank you, Your Honor. Going back to when you found the 19 grams of marijuana in a baggie within that little round talcum powder container, what happened next?
I told Ms. Walford that I was going to have to take her in for booking and that I would return her home. She got a neighbor to babysit for her daughter, and then I drove her to the jail, filled out the complaint, and then I filled out the report for the release and drove her home.
And do you remember what the charge was?
It was a misdemeanor possession of cannabis.
Detective Hayes, do most police officers that go through the City of Austin Police Training Academy get taught that 20 grams of marijuana counts as a misdemeanor, while anything over 20 grams counts as a felony of the 3rd degree, according to the Lone Star Statute, section 398.13?
Objection, leading.
May I respond, Your Honor?
Yes.
I'm simply asking Detective Hayes about his experience in the police academy for the City of Austin, the one that he did go through himself.
I think Detective Hayes can answer that question.
Detective Hayes, would you like me to repeat the question?
Yes, it was long.
Do most police officers know that 20 grams of marijuana counts as a misdemeanor, while anything over 20 grams counts as a felony of the 3rd degree, according to the Lone Star Statute, section 398.13? And I am referring to police officers in the City of Austin Police Department.
They probably don't know the statute section, but they probably know the law.
Do you think Mitchell as a police officer would either know this statute specifically through experience or his training, or just kind of know the gist of the statute?
He should.
Did Miss Walford ever indicate she was guilty of drug possession?
No, she kept on saying continually that Mitchell had planted it.
Detective Hayes, did Miss Walford ever say to you that day, the marijuana is not mine?
No, I never asked her that question directly. She was told we found marijuana and we had to take her to the police station, but I never actually asked her if it was hers. I guess it's because I had a hunch it wasn't.
Why did you arrange a release for Walford?
Like I said, I had a hunch that Walford might be telling the truth.
So Miss Walford passed the smell test.
Yes.
And after you returned Miss Walford home, what did you do?
I wrote a report and delivered the baggie to the crime lab, and then I filed the search warrant return with the judge.
And did you receive a phone call from an assistant state attorney that day?
Yes.
What did the assistant state attorney say to you?
Objection, hearsay.
Same.
Detective Hayes, when you spoke on the phone with the assistant state attorney, did you feel like the assistant state attorney was concerned about the actual search warrant that occurred today?
Yes, she wanted me to fill her in on any facts of the case that were missing from my report. She thought that she wanted to check on Mitchell's stability and was concerned about that.
Is it normal for, Detective Hayes, just to clarify, on Friday, September the 6th, 2019, the assistant state attorney called you. Did she tell you why she called you?
Yes, because Mitchell had called her and had encouraged prosecution of his ex-wife.
Is it normal for an affiant to do that?
No, she said that it seldom happened.
And Detective Hayes, just to clarify, on this same day, Carl Mitchell failed your smell test, but Joy Walford passed your smell test, correct?
That is correct.
Thank you for your time, Detective Hayes. No further questions at this time, Your Honor.
Okay, Mr. Cruz?
May I proceed, Your Honor?
Yes.
Mr. Hayes, you're the detective. You're a detective, correct?
That is correct.
In the state of Austin, in the city of Austin?
Yes,
And Mitchell is an officer, correct?
that is correct.
And you were not his supervisor, right?
No, I was not.
Okay. And Mitchell performed professionally in his work?
Yes, he did.
Okay. And Mitchell does mention his wife at work.
Yes, sorry. Yes, he does. He mentions them quite often.
Sorry, I might not be coming a little bit clear. I might have a little issue with the here, but okay. But Mitchell doesn't mention his wife whenever there's immediate work to be done, correct?
He only mentions his wife when there's no immediate police task, and that's when he goes back into the same rantings.
Okay, so no, he doesn't mention him whenever there's immediate police work to be done?
Objection asked and answered.
You can ask this one last time. I'm a little confused by this line of questioning. Ask
Yes,
again.
Your Honor. May I proceed?
Yes.
Okay. Mitchell does not mention his wife when there's immediate work to be done?
No,
Okay. And him mentioning his wife whenever he does not affect his job performance, correct?
I couldn't answer that because I'm not a supervisor, but I have never seen it affect his job performance.
Okay. And Mitchell performed professionally while there was work to be done?
That is correct.
Objection asked and answered.
Overruled.
Okay. When you received the search warrant, the proposed search warrant from Officer Mitchell, it was around 2 p.m., right?
That is correct.
And you are a law-abiding detective, correct?
That is correct.
And when you received the search warrant, did you take it to the chief?
I did.
And did the chief say that Officer Mitchell would never get a job in the entire state if he lied?
That is correct.
And did the chief allow you to present with Officer Mitchell the proposed search warrant to the judge?
He did eventually after he warned him.
Okay. Your Honor, I would like to direct witness to Exhibit A, which has already been pre-marked in the plaintiff's exhibit and has been shown to the jury. May I go ahead and screen share?
Yes.
Let me see. Detective Hayes, can you see my screen?
Yes, I can.
Okay. Let me go go here really quick. What does, can you see what I'm highlighting here?
Yes, the affidavit and application for search warrant.
Okay, so this is the application for the search warrant, correct?
Yes.
Okay, let the record show that the witness has acknowledged he knows Exhibit A. And let me move forward here. So in the following page, what is this here?
It says search warrant.
Okay, here on this, this search warrant was approved by Judge Crutcher, correct?
Yes, I believe he signed it.
Okay, and this is the same search warrant that you used to have proper authority to search Ms. Walford's apartment?
Yes.
Okay, did the search warrant here, I can show it here, hopefully you can see all of it. Did the search warrant mention anything about Ms. Walford smoking marijuana? I can give you some time.
I don't think so.
Okay, there's a second paragraph over here in the next page. Did the search warrant mention anything here about Ms. Walford smoking marijuana?
It does not look like it.
Okay, and this search warrant, if you don't mind here, let's start reading from here. Let me see if I can highlight this. Doesn't let me, but here starting, correct me if I read this incorrect. For any and all controlled substances, to wit, any and all illegal narcotics. Did I read that correct, Detective Hayes?
Yes.
Okay. I motion for this exhibit to be published in the record, which I believe was already done.
Already admitted.
Let me stop. May I stop sharing my screen?
Yes.
Okay. What is the smell test?
It's something that all police officers have. They assess the facts, and if something doesn't sit right or feel right, they assess the situation and proceed with caution.
Okay, and the search warrant, not the application for the search warrant, but the search warrant that you used, it did not pass your smell test, correct?
Objection. May I approach the bench with my opposing counsel, Your Honor?
Sure. Okay.
Your Honor, I feel that our opposing counsel is trying to misrepresent Detective Hayes's words. When we asked about the smell test, it was in reference to what Mr. Mitchell brought to Detective Hayes at 2 p.m. He's trying to catch Detective Hayes in a battle of words.
Mr. Cruz?
Your Honor, I simply want to know what the smell test was and compare the smell test to the search warrant that was used.
Your Honor, that was not the question that was asked.
Well, okay. Well, my ruling is that he can ask about the smell test and what it is, because I think everyone's smell test is a little different. And I think the jury has the right to understand what Detective Hayes is talking about in the first place. So, Mr. Cruz, you may continue.
Yes, Your Honor.
Oh, you're on mute. I'm sorry.
I'm sorry about that. So just to clarify, the search warrant did not pass your smell test, correct?
The application and the proposed search warrant did not pass my smell test. At that point, when I had the search warrant, then I already had to proceed because I had it authorized by the judge.
Okay, so it did not pass your smell test?
No, but it didn't matter at that point because it was already authorized.
Okay, and the procedure of a warrant is that it must be approved by the judge, correct?
That is correct.
And was the warrant approved by Judge Crutcher?
Yes, the warrant that was signed by the judge, yes.
Yes, okay. Did you find marijuana in the apartment?
Yes,
Was the search warrant that you used correct, that there would be contraband in the apartment?
yes.
Okay. Now let's talk about a little bit about the apartment when you arrived. Did you arrive at Ms. Walford's apartment around 4:30?
Yes,
And it looked like Ms. Walford was drinking when you arrived, correct?
she wasn't drinking. She smelled like alcohol.
No alcohol, okay. And she wasn't drunk though.
No,
Okay. But you would have cautioned her against driving?
I would caution anyone against driving who had been drinking.
Okay, so she was drinking that day?
If she smelled like alcohol, I would assume.
Okay. Did you arrest Ms. Walford?
Yes.
Nothing further, Your Honor.
Ms. Sanchez, any follow-up?
Yes, Your Honor. Detective Hayes, you haven't ever worked with Mr. Mitchell on a case involving his ex-wife, correct?
That is correct.
So can you speak to his professionalism when his ex-wife, a woman he hates, is involved?
No.
Can you say without a shadow of a doubt that Mr. Mitchell is 100% a good police officer?
Objection, speculation.
Your Honor, I'm asking his opinion.
Ask it again.
Yes, Your Honor. Detective Hayes, can you say without a shadow of a doubt, in your opinion, that Mr. Mitchell is 100% a good police officer?
I will sustain that objection.
Yes, Your Honor. Detective Hayes, again, who passes your smell test today between the plaintiff and the defendant?
Miss Walford is the only one who passes my smell test.
Detective Hayes, what was it again that Mr. Mitchell said when you suggested a different alternative to the all-out criminal investigation that he wanted?
He said, nail the bitch.
Thank you, Detective Hayes. The plaintiff rests, Your Honor. May the witness step down?
The witness is excused.
Thank you, Your Honor. And you asked me to remind you if after this, if we could take a quick recess.
Sure, how long would the parties like?
5 minutes would be okay with me. It depends on what you would like.
Let's come back at 4:20.
Thank you, Your Honor.
Your Honor,
Yes.
may I proceed?
Oh, we're gonna take a break till 4:20.
Okay, before we take a break, we would like to move for a motion for directed verdict, if we may.
Okay. Okay, then we will not take a break until 4:20. We'll hear your motion for directed verdict outside the presence of the jury, of course. Okay, Mr. Cruz?
Yes, Your Honor. May I proceed?
Yes.
We move for a judgment as a matter of law for directed verdict. We believe that the plaintiff has failed to provide sufficient evidence to establish and support its cause, that the defendant did not have probable cause for initiating a judicial proceeding against Ms. Walford on September 6, 2019. Specifically, the opposing counsel failed to prove that there was no probable cause in the search warrant that was realized by Ms. Walford, as there was marijuana in the apartment.
Who's
Your
responding?
Honor. Yes, Your Honor.
Ms. Rose, okay.
Your Honor, we believe we have provided more than a sufficient amount of evidence that a reasonable jury would be able to believe that Mr. Mitchell had malicious intent in pursuing the search and arrest warrant, specifically the listening of the testimony of Detective Hayes, that Mr. Mitchell has repeatedly said that he wants custody of his child. The fact that defendant appeared at the plaintiff's residence in direct violation of his divorce papers, and the fact that defendant forced his way into the bathroom, the very bathroom that the marijuana was later found in.
Any response, Mr. Cruz?
Yes, Your Honor. Again, we believe this is a case about probable cause. All of the plaintiffs, the opposing counsel has said that he broke the marriage and that he went to the apartment without having proper paperwork. But again, we believe there was no probable cause to show that he did not have probable cause in the search warrant.
Your Honor, may I reply once more?
Yes.
Just quite simply, probable cause also requires a reasonable search to have suspicion, and we have not heard from defense and how his and their client did or did not have suspicion. So we believe that this motion shouldn't pass because there's still a lot more to do here today.
Yeah, but that's not their burden, is to prove your case. You need to present everything in your case in chief to prove your case, right?
Yes, Your Honor. Well, opposing counsel did not mention in their opening statement that they also have their own burden, an affirmative defense, that their client had reasonable suspicion. So what we've laid out for the jury today is these leading events to probable cause. And what we will later hear is that there wasn't that initial suspicion that completes the routine of probable cause.
But they're not moving for a directed verdict on their affirmative defense, are they?
May I respond, Your Honor?
Yes.
Yeah, Your Honor, I believe that we have no burden of proof here. The burden of proof is on the opposing counsel to show that we did or did not have probable cause in the search warrant. And I believe that they have not shown that up to this point in the trial.
In response, Ms. Rose?
Yes, Your Honor, I'll just stick to our own burden of proof, which is the malicious intent, which is what we've laid out today, that this the nature of this arrest and the events leading up to it are not coincidences, that this should not be taken as a coincidence, that there was that publicity that eventually ended her termination, and that the probable cause was not there because he should not have been at the apartment in the first place. And an officer is supposed to follow the duty of the law, and that it just wasn't there.
Okay, I'll let this go to the jury. I will deny the directed verdict. And now I will grant the request that we take a break. It is now on my watch 4:15. Let's come back at 4:25.
I apologized earlier about my cat. This is exactly why I do not work from home.
I didn't see it or hear it.
Yeah, nor I didn't hear a cat, Judge.
Me neither, but I wish I had.
At least we haven't had anyone appear as the cat filter like that poor lawyer.
Not yet.
I would love to see it though.
I was amazed the judge knew it was a filter. I was just like, how does he, I was impressed.
Yeah.
Okay. Are we ready to go?
Yes, Your Honor.
Okay, so defense, you want to call your first witness?
Yes, Your Honor. I call Officer Mitchell to the stand.
Okay, Officer Mitchell, you are pre-sworn, you understand?
Yes, sir. Yes, Your Honor.
Okay, Mr. O'Leary, you may begin.
Thank you. Officer Mitchell, can you introduce yourself?
Yes, sir. My name is Officer Carl Mitchell. I'm a uniformed officer of the City of Austin Police Department. I've been there about 9 years now.
What do you like about your job?
I love most protecting and serving the community I live in.
Are there any other ways you serve the community outside of work?
Yes, sir. Sometimes I volunteer at the local neighborhood watch committees.
And why did your marriage end?
Objection, speculation.
I think he can testify as to why he thinks his marriage ended.
Thank you.
We got married before we were ready. There were several issues going on, including Joy's money spending and things like that. But the end really came when she got pregnant. I felt she did so intentionally to retaliate against me.
Was this something you said she would do often, her retaliations?
Yes, she said that I often find faults in her too often. So she would intentionally retaliate against me to make me mad.
So let's fast forward a little bit and talk about Friday, September 6, 2019. Why did you go to Angela's house?
Yes, sir. Joy called me earlier that morning. She said that Angela had gotten a cold and wanted me to not take Angela for my weekend. For a long time, I've not felt like I could trust Joy, and I didn't trust what she was saying. It was my weekend to have her, and she didn't give me enough warning for this cancellation. I was really worried about my daughter, so I drove to the apartment to check on her.
I see. So what happened when you got to the apartment?
I got there and Joy was drunk. I insisted on seeing Angela. And Your Honor, do I finish or?
Oh yeah, keep going.
Yes, sir. So I got there and Joy was clearly drunk. I insisted on seeing Angela, and when I saw the baby, she had a stuffy nose and felt feverish. I told Joy I wouldn't take Angela with me this week for my weekend if Joy would promise me to not take another drink, and Joy promised that she would not.
Your Honor, objection to the first part of the witness's answer. He cannot speak to her whether or not she was or was not drunk. He's not an expert. He has no way to measure her blood alcohol content.
Yeah, the jury's already heard it. We'll continue. Mr. O'Leary.
Thank you, Your Honor. So what did you, is that when you went to the bathroom?
Yes, I needed to use the bathroom before I left.
What did you see in the bathroom?
I saw marijuana in her vanity, or in the vanity.
After you saw the marijuana, did you open the door of the vanity?
No, sir. So it was ajar. It was open, and it was already open, and I'm just sitting there, my business. And that's when I saw the marijuana inside.
And how did you know it was marijuana?
I picked it up. I smelled it. I'm an officer. I know what marijuana smells like.
After you smelled the marijuana, what did you do?
I left the bathroom and the apartment and went straight to the police and typed up an affidavit and a proposed search warrant.
So before we get to the search warrant, was anyone else at the apartment that day?
Yes, sir. There were 3 dopeheads sleeping in sleeping bags in the living room.
Speculation.
Sustained. Mr. O'Leary, you can try to ask it again.
Was there anyone else in the apartment that day?
Yes, there were 3 people sleeping in sleeping bags in the living room. None of them were moving when I walked through.
How would you describe the nature of these individuals?
It was kind of shady to me, random people.
Question, speculation.
Yeah, I respond.
Yes.
I'm asking his personal opinion of a description.
Overruled.
I mean, it seemed, or may I? I'm sorry, Your Honor.
Yes.
So it seemed kind of sketchy to me. There were 3 random people sleeping in my ex-wife's apartment. Kind of seemed like dope heads to me. I mean, I'm a police officer, see their kind all the time.
During your marriage, did you ever know your wife to possess marijuana?
I had suspicions.
Okay, let's move on a little bit. What time did you leave the apartment that day?
I got the call about 9 a.m. So I left the apartment sometime later that early morning.
And you left the apartment, and what happened?
I went to the police station, started to fill out the necessary paperwork, affidavit, search warrant, all that.
Search warrants. How would you define probable cause?
Objection. This witness is not an expert. Has not been called into this trial as an expert.
Response.
Yes.
He is a police officer. I'm not claiming him to be an expert, but I'm asking his own opinion of how he would define it. I'm not trying to claim he's an expert.
Your Honor, may I respond?
Yes.
The question relayed no information about, in your opinion. Also, as a police officer, he does not write the law.
Correct. So there's a way to handle this, Mr. O'Leary and Ms. Sanchez, which is maybe read what the law is of probable cause and ask him a question about it. But he doesn't get to answer or guess about what that legal standard is.
Yes, Your Honor. May I proceed?
Yes.
Officer Mitchell, would you say it is true that probable cause is defined as whenever a police officer has a reasonable ground of suspicion of a criminal supported by all the circumstances enough to warrant a man that there is a belief that someone is guilty of an offense?
So as an officer, I do know I don't know if it's defined technically in the state of Texas, but broadly, yeah, you have some suspicion, you see something, you make a logical conclusion, there it is.
And so what was your probable cause, in your opinion, for going forth with a search warrant?
I was in the restroom. I saw marijuana in the bathroom. It was Joy's bathroom. Simple as that.
And then what happened after that?
After signing the affidavit, all that part.
After you saw you had probable cause to go, you felt you had probable cause to go forward with the search warrant.
Question asked and answered.
That's okay. Ask your next question, Mr. O'Leary.
What happened after that?
Yes. So I took the affidavit and the warrant to Detective Hayes, who took me to the chief. The chief told me he would authorize it, but with the caveat, if I was lying or he felt any undue suspicion about this, he would make sure I would not be hired in this state of Lone Star as a police officer ever again. I took that really seriously. So he let me go to Judge Crutcher with this, with the search warrant. The judge swore me in. I signed the affidavit in his presence, and Judge Crutcher signed the warrant.
So why did you take it to all these people?
This is sensitive. It's a sensitive matter. I know how it would look. This is my ex-wife, but there are strict police procedures for applying for a search warrant and doing all these things. I want to go by the book. I don't want this to not, I don't want to go against the book.
What interactions have you had in the past with criminals who possess marijuana?
So I see it all the time. Most of the time, vast majority of the time, I turn them in. Sometimes teenagers, youngsters, I give them a break, seize the marijuana, throw it in the sewer.
Okay. I want to ask you a little bit about a phone conversation you had. Can you tell me about a conversation you had with the supervisor of the misdemeanor division in the state attorney's office?
Sure. I called this supervisor after the arrest. I truly felt that my child's safety was at stake. But in full ethical disclosure, I even put this in my affidavit. I decided to tell the prosecutor that I was the affiant on the search warrant. I wanted to make sure they knew that, just because to be by the book, I needed to be upfront. I could not ethically comment on anything past that, the fact that I was the affiant. I don't want to face departmental discipline for trying to influence a prosecutor or something untowards.
Thank you, Your Honor. I pass the witness.
Okay, Ms. Sanchez.
Thank you, Your Honor. Mr. Mitchell, is it safe to assume that you're potty trained?
Yes, but when you got to go, you got to go.
Have you ever held your bladder in your life before?
Objection, relevance.
Your Honor, may I respond?
Yeah. Yeah,
The
sure.
witness himself said that he had to go to the bathroom, so he couldn't wait, so he went at Miss Walford's house. I'm simply asking about his experiences holding his urine before in the past and why at that moment he had to go.
Well, I think we can move forward. Why don't you ask your next question?
Thank you, Your Honor. Mr. Witness, you decided at Miss Walford's house that you couldn't hold it for a second longer, correct?
Yes, I suppose so. I really couldn't.
Mr. Mitchell. Mr. Mitchell, you and Ms. Walford have been divorced for about 2.5 years, correct?
It's 2018, I think. Yeah.
Okay. And after 2 years, why do you still talk about her often enough for people at work to know about it and not really feel comfortable working with you?
Well, I pay her $500 a month, so I mean, it hurts the pocketbook when that happens.
Do you feel that every father who is simply paying for his child's needs should complain about it?
I mean, it's kind of a commiseration thing. Sometimes it comes out of your pocket. I'm glad to just provide for Angela. That's my duty as a father. But I mean, $500 out of your pocket every month, you just have to have something to complain about. It gets you through the day, like any coworkers would.
Thank you for explaining that, Mr. Mitchell. Mr. Mitchell, you only see Miss Walford every other weekend, correct?
Roughly at our exchanges, yes.
Absolutely. And Your Honor, may I approach the bench before I start this next line of questioning?
Yes.
Your Honor, I am approaching the bench in regard to the motion in limine brought forth by the defense at the start of this proceeding, the one that you did approve about the lie detector test. I would like to start a line of questioning related to the lie detector test only because my opposing counsel brought it up during their cross of Miss Walford. They themselves brought it into the conversation.
Mr. O'Leary?
We objected to the results of that test, and the results of the test are not going to be able to be verified. So as long as it has nothing to do with the actual results of the test, I would have no objection to that.
What do you want to ask?
I'm simply asking about whether or not he has refused a lie detector test. There is no mention about results.
The other question was about her lie detector test. Is that right?
The one that was in cross?
Right. That was about hers.
Yes, Your Honor. They asked her if she had taken a lie detector test that was offered to both her and Mr. Mitchell.
And she testified about hers. She didn't testify about Mr. Mitchell's, did she?
Correct, Your Honor, but they did bring it into the conversation.
Well, you didn't object to it at the time.
Correct, Your Honor.
About hers. Mr. O'Leary, do you have a response?
That's correct. What she is saying, that we brought it in regards to her and not him. So I don't, we may have mentioned it in regard to the plaintiff, but we have not mentioned it in regard to the defense.
So what's your position on this, Mr. O'Leary?
I believe that there's no reason for this line of questioning to continue.
Because what's the legal reason? Do you have an objection?
No, sir.
Okay, then I will allow it in.
Thank you, Your Honor.
Unless you have a objection to it that you can state.
I mean, can I try to state an objection?
What objection do you want to make?
It's towards the expert testimony that we don't have with the results.
Your Honor, may I respond?
Sanchez, what questions do you want to ask about it?
I'm not asking about the actual results of the test. I'm simply asking if he was offered to take a lie detector test.
Do you have an objection to that, Mr. O'Leary?
No, sir. No, Your Honor.
Okay, then I will let her ask that question.
Thank you, Your Honor. May I proceed?
But you're on a very narrow leash here, Ms. Sanchez.
Yes, Your Honor.
Okay.
Mr. Mitchell, have you refused to take a lie detector test in the past?
I'm going to be honest, it's not in my deposition, so I'm going to assume no. I've not been offered a lie detector test.
Yes, Mr. Mitchell, we can proceed. Mr. Mitchell, when you went to the bathroom at Miss Walford's house, you saw the door ajar in the vanity, correct?
The vanity door was ajar, yes.
Perfect. And that prompted you to look inside that vanity door that was ajar, correct?
When you're just standing there and you're looking up and there's a vanity, I mean, you just look
I'm
up.
so sorry to interrupt you, Mr. Mitchell. I am going to ask that you just answer the questions that I am providing you with today. Would you be okay with that?
Sure.
Thank you, Mr. Mitchell. Mr. Mitchell, when you saw that that vanity door was ajar, it prompted you to look inside, correct?
What do you mean look inside?
Look inside the vanity.
Yeah, I looked up and it was there.
And after you looked inside the vanity, you saw the marijuana was in there, correct?
Yes.
And so then you have mentioned that the probable cause that you had for today's case was the marijuana that you saw inside the vanity, correct?
Yes.
Why did you even look inside the vanity? What was your suspicion to even look inside?
Well, mechanically, I was sitting down. I just look up to pass the time. I didn't have my phone on me. And there it is.
It's a lot of steps. You were sitting down to empty your bladder, correct?
I had to use the bathroom.
Interesting. Thank you, Mr. Mitchell. Mr. Mitchell, it's not illegal.
And stand up to pee.
Mr. Mitchell, would you be okay if I can?
Detective Mitchell, just let Ms. Sanchez ask you questions.
Yes, sir. Yes, Your
Thank
Honor.
you, Your Honor. Mr. Mitchell, it's not illegal to consume alcohol in your own home, correct?
No, it is not.
Mr. Mitchell, are you a police officer?
Yes.
And would you say that you're a good police officer who's simply trying to follow the law?
Yes, I'm trying to uphold my oath.
And you were just trying to follow the law on Friday, September the 6th, 2019, weren't you?
Yes, I was.
And as a police officer, you were trained in the law, correct?
Yes.
You swore an oath that you just mentioned, correct, when you were signed in as a uniformed police officer, is that right?
Yes.
And Mr. Mitchell, this oath you swore was to uphold the law, correct?
Yes.
Mr. Mitchell, during your 8 to 9 years as a police officer, have you ever seized marijuana?
Yes, I have.
Is it possible that in your 8 to 9 years as a police officer, you may have seized a small baggie of marijuana at one point?
Yes, absolutely.
Mr. Mitchell, when seizing marijuana from citizens, you're protected from also being considered in possession of this marijuana because you're being a good police officer and actively following the law, correct?
I believe that's how it works, yes, ma'am. Yes.
And Mr. Mitchell,
Yes.
these citizens, oh, I'm sorry. Mr. Mitchell,
I was trying to address you correctly, sorry.
Mr. Mitchell,
Sanchez.
these citizens, like Ms. Walford on the day in question, are considered to be in possession because they're not acting in a capacity of a police officer, correct?
Objection, speculation.
No, you can answer that question.
Mr. Mitchell, these citizens, like Ms. Walford on the day in question, are considered to be in possession because they're not acting in the capacity of a police officer, correct?
Yes, it's in their house, it's in their possession.
Mr. Mitchell, do you always turn in marijuana that you seize during a citizen encounter or arrest?
No, I don't. As I've previously talked about, youngsters, people like that have a small amount. I'll throw it in the sewer or something, but this was a felonious amount, so I had a lot more concern about it.
I'm so sorry, Mr. Mitchell. I don't want to move for anything. Would you mind just answering my questions from now on?
I believe I did.
Without any extra elaboration, just the question at hand. Is that okay?
So,
I feel I have the right.
Ms. Sanchez, you would like me to instruct the witness?
Yes, Your Honor. If I could, I didn't want to move for non-response, but if I need to, absolutely.
But Ms. Sanchez, when I'm talking, please don't interrupt me
Oh,
either.
I'm so sorry. Yes, Your Honor.
Okay. So, Detective Mitchell, if you will only answer the question that Ms. Sanchez asks you, and your attorney will have time to
Yes.
follow up if they need to. You understand?
Yes, sir. So just, do I get to contextualize or just go for it for the answer?
Well, answer the question to the best of your ability, truthfully. And if there's context needed, then perhaps we'll see how much you can fill in. But it depends on the question.
Yes, sir.
Ms. Sanchez?
Yes, Your Honor.
Thank you, Your Honor. Again, forgive the interruption. I did not mean to. May I proceed?
Yes.
Mr. Mitchell, do you always turn in marijuana that you seize during a citizen encounter or arrest?
No, I do not.
And
Sometimes I throw it away in a commode or in a sewer, as I've described. Yes, ma'am.
thank you. And the law requires you to turn in seized marijuana, doesn't it?
Police officers have a certain amount of discretion.
Your Honor, I move for non-response again.
He has some leeway to answer your question. So that time I think he was fine. But
Yes, Your Honor.
I will keep umpiring this.
Thank you, Your
Okay.
Honor.
Proceed.
Mr. Mitchell, does the law require you to turn in seized marijuana during a citizen encounter or arrest? Yes or no?
I believe so, yes.
Thank you, Mr. Mitchell. And the law doesn't allow for creation of different legal protocols simply because a police officer feels like it or sees a reason to, does it?
No, but it's often the practice.
The practice is to break the law as a police officer?
No, the practice specifically is to often throw away a youngster's amount of
Thank
marijuana.
you for explaining, Mr. Mitchell. If you could please answer regarding my question specifically. Again,
Yes.
I'll ask, okay? The law doesn't allow for creation of different legal protocols simply because a police officer feels like it, does it?
Correct.
In your role as a uniformed police officer, do you have the legal privilege of choosing when to follow the law and when to break it?
I'm not sure if I understand your question.
I can rephrase it. Is that okay?
Yes, please.
Thank you. Mr. Mitchell, in your role as a uniformed police officer, do you have the right, according to the law, of choosing when to follow the law and when to break it?
Objection, compound question.
You all approach the bench.
Yes, Your Honor.
Your
Ms. Sanchez, I think we've talked through this enough. And I think you should just move on.
Yes, Your Honor.
Thank you, Your Honor.
Okay,
May I continue?
please.
Yes, you do. Please.
Thank you. Mr. Mitchell, when Detective Hayes offered you an alternative to criminal prosecution for Ms. Walford, you outright refused, didn't you?
As in what? Can you repeat that? I'm so sorry.
Yes, Mr. Mitchell. When Detective Hayes offered an alternative to criminal prosecution, which was the Child Welfare Department, you refused, didn't you?
I can't speak to the child welfare part, but he did try to talk me out of the search warrant. Yes.
And you did refuse, correct?
Yes, because I was very adamant for my child's safety.
Again, Mr. Mitchell, I'm so sorry. I'm just asking you to answer my direct questions.
Yes, ma'am.
Thank you. Mr. Mitchell, on September 6, 2019, did you get approval from Detective Hayes, the Chief of Police, and Judge Crutchner for enactment of the search warrant?
Yes, it was signed by all the appropriate protocols.
Thank you. And you trust their judgment and their ability to do their jobs, correct?
Yes.
And you're agreeing with the final judgment to get the search warrant on that date, correct?
Yes, I do.
Detective Hayes mentioned you told him Miss Walford was smoking when you arrived at the apartment and that your story didn't pass his smell test. Should we believe Detective Hayes still?
I think he's a fair officer and that he was able, I'm very glad he was able to express any concerns,
Thank you.
but
Mr.
I don't know
Mitchell-
what he said earlier.
Thank you, Mr. Mitchell. Have you ever said that you pay Miss Walford alimony?
I think I did in a deposition, but I'm pretty sure I mixed it up with child support just because I'm not an accountant or an attorney. I'm just a police officer.
Thank you, Mr. Mitchell. And you know the law, correct?
Yes.
And knowing
Barely.
the law, I'm sorry, Mr. Mitchell, knowing the law means knowing legal documents are drafted correctly and having to check for that, correct? Just like your search warrant and affidavit. Is that right?
Yes.
Mr. Mitchell, did you call the Assistant State Attorney on Ms. Walford's case that day?
Yes, to let them know I'm an affiant.
Mr. Mitchell, after your call with Ms. Walford the morning of September 6, 2019, you were upset and worried about your daughter. Is that correct?
Yes, I was.
Does your final dissolution of marriage with Ms. Walford qualify as a legal document?
Yes, it does.
You ignored a legal document in a court order then, correct?
Yes, I did, and I was very concerned about my daughter. I know there's no exception, but I was feeling very strongly and ready to take the repercussions.
Your Honor, I again move for non-response.
I think he was fine. You can
Okay.
continue.
Thank you. Mr. Mitchell, you claim one of the reasons you decided to get Ms. Walford was to protect your daughter. Is that correct?
Yes,
Leaving your daughter in a home with her supposedly drunk mother, who also supposedly had a brick of marijuana, doesn't seem very protective, does it?
may I explain a little bit on that?
I would ask that you just answer my question.
Well, there were 3 people in the apartment as well, and that's what gave me greater concern for her long-term.
Mr. Mitchell, I'll go ahead and ask the question again.
Yes.
Leaving your daughter in her home with a supposedly drunk mother, who also supposedly had a brick, doesn't seem very protective, does it?
It is not. I followed proper procedure.
Mr. Mitchell, do you have a girlfriend?
Yes, I do.
What is your girlfriend's name?
It is Miss Sanchez, or it's
Miss Alvarez, maybe?
excuse me, Stephanie Alvarez.
Miss Alvarez works.
I hope she's not on the live stream. Okay.
May I proceed, Your Honor?
Yes, please.
Thank you. And Miss Alvarez works for a news reporter on Channel 8 News, correct?
Objection, relevance.
Overruled.
And Miss Alvarez works as a news reporter for Channel 8 News, correct?
Yes, she does.
Is this the same Channel 8 News that was outside of Miss Walford's residence when Detective Hayes arrived to search the apartment?
Yes, I believe it was. I wasn't there, but I believe from the reports I read, it was that one.
Thank you, Mr. Mitchell. And Mr. Mitchell, if you saw 907 marbles in one jar and 19 in one jar, would you say that that's a really different amount?
Yes.
And would you consider yourself experienced around marijuana due to your experience as a police officer?
Yes.
Did you ever suspect Miss Walford possessed marijuana during your marriage to her?
I had suspicions.
But you never had concrete evidence of this suspicion, correct?
No.
It's true then that in 4 years of marriage, you never came across a shred of proof that Miss Walford possessed marijuana, correct?
Correct. I had suspicions.
And it's also true that after not going to Miss Walford's apartment, you all of a sudden have the alleged proof of a 2-pound brick of compressed marijuana during a quick bathroom break, correct?
I apologize. Can you repeat that? I'm trying to
Absolutely, yes.
listen.
It's also true that after 2 years of not going to Miss Walford's apartment, because you've been abiding by the final dissolution of marriage, you all of a sudden have the alleged proof of a 2-pound brick of compressed marijuana during a quick bathroom break, isn't it?
Well, to clarify, it hasn't been 2 years since I've been there because we had our spats. So it's been a more recent development that I haven't been there. So it's been a shorter time frame than that.
Are you referring to the spats during your separation before your divorce?
Before it was finalized, yes.
Right.
Or during our exchanges, yes.
So before the divorce, yes. So I'm speaking to the time after the final dissolution of marriage, when your divorce was finalized, about 2 years, not going to her.
Okay, yes.
Thank
Yes,
you.
then.
Of not going to her
Thank you.
apartment, you all of a sudden have this alleged proof of a 2-pound brick of marijuana during a quick bathroom break. Is that correct?
Yes.
And Mr. Mitchell, last question. Thank you for your patience today. Probable cause does not exist if it's manufactured, correct?
It does not. No.
Thank you, Mr. Mitchell. No further questions.
Okay, Mr. O'Leary.
The defense chooses not to redirect.
Okay, then Mr. Detective Mitchell, you can step down.
Thank you.
Please call your next witness.
Yes, Your Honor. The defense calls Dana Wood to the stand.
Dana Woods. Miss Woods, how are you?
I'm well. How are you?
I'm fine. You are pre-sworn, so tell the truth. Okay, Mr. Cruz, you may continue.
Thank you, Your Honor. Could you introduce yourself to the jury? Tell us a little bit about yourself.
Yes, so my name is Dana Woods. I am a retired school teacher and I am a widow with 4 beautiful children, the youngest of which is 26.
And do you know Joey Walford?
Yes,
What's your relation to Joey Walford?
she is my neighbor and I babysit for her, but I wouldn't consider us close friends.
How often do you babysit for her?
Now that she works at the 7-Eleven, I babysit every day.
And as a neighbor and babysitter, what kind of mother would you believe that Ms. Walford is from what you have seen?
She could be better.
She could be better. Could you elaborate on that a little bit, please?
Yes, I have smelled alcohol on her breath when I babysit for her.
How are you so sure that you smelled alcohol on her breath?
Well, to tell you the truth, I used to be an alcoholic myself. Thankfully, I haven't had a drink in 25 years, but I know it when I smell it.
Okay. Who else, if anyone, that you've seen resides in the apartment?
Besides Angela, she has a boyfriend that she spends a lot of time with at the apartment.
Objection, Your Honor. May counsels approach the bench?
Yes. Okay.
Your Honor, as we talked about earlier, you granted our motion in limine to strike Ms. Woods from being able to label Brad Pitt as the boyfriend, as she has no evidence of this. If you could please remind the jury that she doesn't have any of this, and maybe we could strike this from the record.
Mr. Cruz?
That she had no evidence of what, I'm sorry?
That Mr. Pitt is allegedly the girlfriend. Did you instruct your witness that she can't testify as to that?
Yes, Your Honor. I mean, we haven't touched about Brad Pitt. We've only asked about the kids and if anyone else has been in the apartment. We haven't asked about that or won't ask about that.
May I reply, Your Honor?
Yes.
The witness just stated, used the word boyfriend, and that has been precluded from today's testimony at the beginning of this trial during the motion in limine.
Right. So, Mr. Cruz, did you instruct your witness not to refer to Brad Pitt as the boyfriend?
I believe so.
Okay. What would you like me to do, Ms. Rose?
Would you please?
Oh, sorry.
Would you please strike it from the record and alert the jury that Ms. Woods actually does not know if he's the boyfriend?
Okay, I can do the latter. I cannot do the first because nothing can ever be stricken from the record.
Yes, Your Honor. Thank you.
If it's on the record, we do not, as a matter of course, remove it from the record.
Yes, Your Honor. Thank you for the clarification.
We like to say that, but it never happens. So just be careful and practice. Even I'm sure Mr. Dawson will say strike it from the record, and it doesn't get stricken from the record.
Yes, Your Honor. And because you've just clarified that for me, which I appreciate, could I go ahead and remind opposing counsel that you've also eliminated out Ms. Woods being able to speak to the opinions of the neighbors? She's only able to speak to her own opinions.
Mr. Cruz, did you discuss that with Ms. Woods? Does she know not to go into that?
Yes, Your Honor.
Okay, and a way for her not to go into that is make sure you ask the right questions.
Yes, Your Honor.
Okay, whereas else it's a violation of the motion to eliminate, which could mean I could declare a mistrial and your client would bear the cost of the entire proceeding.
Understood, Your Honor.
Okay. Ladies and gentlemen, jury, we will disregard Mrs. Wood's testimony that Brad Pitt may or may not be the boyfriend. Okay, you may proceed, Mr. Cruz.
Thank you, Your Honor. Does anyone else reside in the apartment or stay in the apartment that you have seen?
Yes, besides Angela, there's a very close friend that spends quite a bit of time at the apartment. There are also some spiky-haired kids wearing metal chains that hang around the apartment as well.
Okay. What do you think of those kids?
Well, I don't know them personally, but they do appear to be younger than 21. They do smoke a lot of cigarettes and just come off as a bit sketchy.
Have you ever seen anybody with drugs in the apartment?
No, but they do smoke a lot of cigarettes, and I did see some cold hand-rolled cigarettes that smelled different than tobacco in there one day.
Let's talk about Officer Mitchell. Do you know Officer Mitchell?
Yes.
How do you know Officer Mitchell?
He has come to Miss Walford's apartment to pick up the child, and he also comes to speak at our neighborhood watch program.
Nothing further, Your Honor. I pass the witness.
Okay, Ms. Rose.
Ms. Woods, you like Miss Walford, correct?
I mean, we're not close friends, but yes, I wouldn't say I disliked her.
Okay. Ms. Woods, you do not know Mr. Mitchell personally, as you've just stated. Is that correct?
No, but he is a police officer and I respect all police officers.
So because you don't know him personally, you cannot actively speak to his character. Is that correct?
I mean, I can speak to what I've observed as he's been there.
Yes, but you cannot speak to his character, only your observations, as you've just stated, correct?
Can you please define character?
Yes, I'm just going to be asking your specific observations. I'm not going to ask you to go into if he's a good father, a good person, or a good police officer. You don't know him personally. Is that correct?
Yes.
Ms. Woods, you have seen altercations outside of Ms. Walford's apartment. Is that right?
Yes.
Ms. Woods, who were the people involved in these altercations?
It was Mr. Mitchell and Brad Pitt.
Okay. Ms. Woods, have you any reason to believe that Angela was also present during some of these altercations?
I wasn't in the apartment, so I can't speak to that.
Okay. Is there any verbal or audible confirmations that Angela was around during some of these altercations?
Not that I'm aware of.
Okay. Ms. Woods, is it your testimony today that you have no proof that Angela was there?
Yes, because I was not in the apartment, as I said earlier.
Yes, Ms. Woods. You remember giving a deposition to this case, is that right?
Yes.
Okay. And Your Honor, may I screen share so that I can refresh the witness's memory?
Yes.
Ms. Woods, do you see your own deposition on my screen?
Yes, I do.
Okay. I'm just going to scroll down here a little bit. This is page 28 of the record. Ms. Woods, I'm going to read 1, 2, 3, the third answer from the bottom of the page. The boyfriend was often there and there was a lot of yelling and screaming and the child would cry. Did I read that correctly?
Yes, you did. I apologize.
Oh, that's totally fine. And just one more line right after that. I saw Mitchell and the boyfriend push each other in the walkway. Several neighbors came out to look.
Yes, but I don't think I contradicted myself on that.
I'm not saying you did. Thank you for clarifying what I'm saying. I just was finishing the sentence. Thank you, Ms. Woods. Have I stopped sharing my screen?
Yes.
Ms. Woods, instead of remaining calm around his daughter, Mr. Mitchell chose to engage in this aggressive behavior, correct?
Yes.
Ms. Woods, have you ever seen these kids that you mentioned that look odd possessing actual drugs?
No.
Okay. Ms. Woods, would you agree with me that not all children are the same?
Yes.
And Ms. Woods, you mentioned that you have 4 children and that you are a retired school teacher, yes?
Yes.
Okay. Ms. Woods, as you've just mentioned, not all children are the same, and you do have your own experiences as a mother. These are based on your own children and being a retired teacher. Ms. Woods, that's what we call subjective information. It's based on personal interpretations and just personal opinion, interpretation, and points of view. Objective information is based in facts. So I'm just going to ask you a couple fact-based questions. Ms. Woods, have you ever felt the need to notify welfare authorities regarding Ms. Walford's care of Angela?
No.
Ms. Woods, Angela is typically clean, well-fed, and properly clothed, correct?
Yes.
Ms. Woods, Ms. Walford has exhibited proper care for her child in these 2 years you've known her, correct?
Yes.
And Ms. Woods, you've never smelled marijuana, correct?
No.
Ms. Woods, you have never seen Ms. Walford under the influence of drugs, correct?
No.
Ms. Woods, you have never seen Ms. Walford drunk, correct?
No, but I mean, I have seen her drinking.
Thank you, Ms. Woods. Just one more time, and please answer just yes or no. Ms. Woods, have you ever seen Ms. Walford drunk?
No.
Thank you. No further questions.
Okay, Mr. Cruz.
The defense has decided not to redirect. Your Honor, I only ask for the witness to be excused.
The witness is excused.
With that, the defendant rests our case in chief, Your Honor.
Okay. Anything else?
No, Your Honor. Just a reminder that we have a brief recess before closing.
Okay.
Your Honor,
Yes.
if I may, we wanted to move the motion for directed verdict again, if we may.
Okay.
We move for a motion for a judgment as a matter of law for directed verdict. We believe that the plaintiff once again has failed to prove sufficient evidence to establish and support its cause that the defendant did not have probable cause for initiating a judicial proceeding against Ms. Walford on September 6, 2019. Specifically, the opposing counsel has fared their burden of proof to show that there was probable cause in the search warrant. There was not probable cause in the search warrant that was realized by Mr. Walford in Ms. Walford's apartment.
Is this the same motion you did before?
Yes, Your Honor, we just want to bring it up again.
Okay, it's denied. Let's take, how long do you want?
5 to 10 minutes is okay with plaintiff.
Mr. Cruz?
That is fine with us as well, the defendants, Your Honor.
Okay, I have, oh wait, it's a public safety alert. It's gonna, bad weather tonight. It's 4:56 on my watch. No, it's not. What time is it?
It's 5:05, Judge.
Yeah, why is that? Okay, there it is, 5:05. Let's do 5:15. Is that Judge Weems? Is that's not the Dawson Cup in Alistair's picture, is it? That's the World Series trophy, isn't it?
That is the World Series trophy, Judge.
I thought it should be the Dawson Cup. It should be like that thing should be there.
I don't have possession of that right now. It's somewhere at 201 Caroline.
I have it. I have the Dawson Cup right now. It will come to you shortly, Miss Judge Miller, whenever I'm ready to relinquish it.
Okay.
So the short story on the World Series is I went to a charity event at the Museum of Fine Arts, and they brought it in and they put it upstairs. And I was sitting with Barrett Reisner and Frank Vandiver, and I was like, the trophy's up there. There's nobody up there. Let's go get our picture taken. So we all went up there and stood next to her, and we took each other's pictures. And then later that night, somebody bumped the table and the table crashed and the trophy got broken. And they had to repair it there at the Museum of Fine Arts. But that was not, I can assure you, that was not me, it was not Barrett, it was not Frank Vandiver.
Mm-hmm.
I heard about it. Well, if it needs to be fixed, the MFAH is a great place to get it fixed for sure.
Yeah, apparently they took it downstairs and voila, it all got taken care of. So that's my picture on Zoom.
That's great. Okay, so we are now in closing arguments. Is that where we are?
Yes, Your Honor.
Okay, and who's going first?
That would be me, Your Honor. Ms. Rose for plaintiff.
Okay, Ms. Rose, the floor is yours.
May I reserve 2 minutes for rebuttal?
Sure, and the bailiff will let you know.
Thank you. May it please the court.
Yes.
Detective Hayes has testified today that Carl Mitchell stated, "Nail the bitch," when asked if he was sure if he wanted to proceed with an affidavit for a search warrant of his ex-wife's residence. These are the words of someone about to put into motion an incredibly serious accusation. Carl Mitchell was off duty. He was angry and he had power. Carl Mitchell was not acting within the scope of his police duties to uphold the law. Carl Mitchell was releasing into action a malicious and pent-up agenda against Joy Walford, the mother of his child. This is not a he said, she said walk around. This is about power. Carl Mitchell knows the law. He knows what it takes to meet probable cause standards. He knows that possession can be actual or constructive. Carl Mitchell knows how to nail the bitch. At the beginning of this trial, my co-counsel asked you to consider, is Mr. Mitchell telling the truth? It's time to answer that question by looking at what we have seen and heard today. Today, we heard from Joy Walford that on September 6, 2019, years of mutual loathing, disrespect, and scorn came to fruition. But there was only one victim, Joy. Joy cannot teach in this state anymore. She suffers from reduced wages and mental anguish. She now lives with her community, thinking the worst of her as a parent and as a mother. Carl Mitchell showed up in direct violation of his divorce agreement, and Joy allowed him to see their daughter, to see that she was indeed sick. Joy told you that she did not call the authorities out of fear that his fellow cops would show up and take his side. Carl Mitchell used the restroom, came out, agreed to let Joy care for Angela over the weekend, thus swapping weekends, and he left. Within about 6 hours, Detective Hayes was knocking on her door with a search warrant. That is power. Carl Mitchell, Your Honor, Ms. Walford told you that she had had one beer and was starting at around 4 or 5 to open up the second one when Detective Hayes arrived. Joy was humiliated as she was walked out of her house for possession of marijuana that was not hers, and conveniently a Channel 8 news team was ready to roll. They knew who Joy was, what she did for a living, and why she was being arrested. Carl Mitchell's girlfriend works for Channel 8 News. Ms. Walford was fired from her job as a teacher because of this publicity. Today, we also heard from Detective Hayes and Carl Mitchell. These two testimonies have grave inconsistencies, so it will be up to you, jury, to evaluate the credibility of these witnesses. Detective Hayes told you that Ms. Walford was not slurring her words and was in complete control of her balance. He told you he had no reason to believe that she was unable to care for her child. But Defense would like you to believe that Joy Walford was drunk when Mr. Mitchell got to the apartment at around 11 a.m., albeit there has been no proof of this. Detective Hayes told you today that Carl Mitchell is a loose cannon. Detective Hayes told you about Mr. Mitchell's constant commentary on his disdain for Joy and how the judge screwed him. Exhibit A, the affidavit application of search warrant that was signed by Carl Mitchell, states that Mr. Mitchell saw a 2-pound brick of marijuana in the apartment of Joy Walford. In that very same exhibit is the return of search warrant signed by Detective Hayes, stating that one baggie with a small amount of suspected marijuana was found. Defense wants you to believe that Miss Walford somehow disposed of nearly 907 grams of marijuana, but left just a little bit behind. Jury, is it odd to you that a police officer would confuse 2 pounds of marijuana with about 2 ounces of marijuana? Mr. Mitchell testified today that the law requires he turn in confiscated marijuana, but he does not always comply. He told you today that he sometimes does not arrest people in possession of marijuana to give them a break. For someone who picks and chooses when to comply with the law, it is hard to see that his pursuit of a search warrant of Miss Walford's apartment, the main residence of his daughter who had sole custody, was merely because it was his duty as a police officer. It is not hard to see that this was a power move. The state of Lone Star voluntarily decided not to prosecute Miss Walford for the criminal charge of possession of marijuana. And yet, Carl Mitchell was so confident in his pursuit of the search warrant that he was willing to risk his career on it. But the state of Lone Star dismissed the case anyways. The fact is, Carl Mitchell thinks he can get away with this because of power. Our fourth witness today was Dana Woods. Mr. Mitchell claims that he was motivated by the protection of his daughter. You heard from Dana Woods, the neighbor of Joy, babysitter of Angela. Ms. Woods told you that Angela is properly cared for and that there has never been a need to alert authorities to the welfare of Angela. Woods was only able to offer you her opinion based on her merits of motherhood. Not only do these inconsistencies between Detective Hayes and Carl Mitchell, but defense conveniently glazes over the fact that Mr. Mitchell was so concerned and so motivated by the well-being of his daughter, and yet he left her there with what defense wants you to believe was a drunk mother in possession of 2 pounds of marijuana. Could this be because Miss Walford was not actually drunk, that 3 dope heads were not actually there, and that he knew the marijuana would soon be confiscated? Miss Walford did not indicate there was any emergency when she talked to Mr. Mitchell on the phone. This is neither suspicion nor probable cause in the divorce papers for him to show up. This is the first indicator that there was no actual basis for Mr. Mitchell's suspicion to look in the bathroom and later claim he had probable cause. Carl Mitchell did not have reasonable suspicion to 1, even look inside the vanity bathroom, and 2, to execute the search warrant to Miss Walford's apartment. Rather than reasonable suspicion, we believe that Carl Mitchell did have power and motive. My co-counsel, Ms. Sanchez, talked to you earlier about our burden of proof. We must show that Carl Mitchell did have malicious intent and that he did not have probable cause. Though Detective Hayes and Joy Walford, you have heard Carl Mitchell refer to Walford as by way of nail the bitch, and how he was not even supposed to be at the apartment in the first place. Detective Hayes told you that a state attorney called him to inquire about the nature of the charge against Mr. Mitchell because it was so odd that he had reached out to her. Ms. Walford told you today that a news team knew her name, job, and the charge and were stationed outside her apartment just in time for her arrest. Out of the 6 people that knew the search was happening, the only one that news correspondent Stephanie Alvarez knew was her boyfriend, Carl Mitchell. Defense wants you to believe that this is a coincidence. We disagree. We believe that these admissions are direct evidence of the malicious intent Mr. Mitchell had towards Ms. Walford. As if an unwarranted visit by Mr. Mitchell was not enough, the charge of possession was not enough, public humiliation had to be a component too. Jury, we also laid before you the evidence of Mr. Mitchell's lack of probable cause. It is important to note that probable cause only exists when it is not manufactured. What's the probability that after almost 3 years of marriage and no proof of her committing a crime, that upon a hunch, Mr. Mitchell found exactly what he needed the day he came over, violated the divorce papers, and forced his way into the bathroom. And upon entering the bathroom, Mr. Mitchell sees a door ajar and looks inside. Jury, this is Mr. Mitchell searching without reasonable suspicion, without probable cause. Jury, we believe that this evidence indicates there was none. Jury, it is your job now to weigh the evidence laid out before you on the scale of justice. This hatred has led to an abuse of power in the form of a malicious and unconstituted criminal proceeding against Ms. Wofford, based on a lack of suspicion and a lack of probable cause. The fact is, Mr. Mitchell cannot and should not get away with using his power as a police officer to breathe life into his hatred for Ms. Wofford. Carl Mitchell had malicious intent towards Joy Wofford. Joy Wofford, he had malicious intent towards her, and he abused his power as a police officer to insinuate that he in fact had probable cause. What Mr. Mitchell failed to take into account was the fact that probable cause, or a manufactured version of one, does not excuse the consequences of your actions. It does not excuse the news team pushing publicity to ensure Joy got fired, or the pressuring of a state attorney to prosecute the case, or to sit here today and say you did not have malicious intent to injure Joy's livelihood. Carl Mitchell did take into account the power he had to see these events through. Thank you.
Okay, thank you very much. Mr. O'Leary, are you closing for the defendants?
Yes, Your Honor. May I please the court?
Yes.
Ladies and gentlemen, the jury, the first thing I want to do is ask Mr. Santa Cruz to pull up the verdict charge for today. I just want to remind everybody what this case is about. Mr. Santa Cruz, could you share your screen? Okay. If you'd like to read along with me, I'm going to read this out loud. Verdict. We, the jury, return the following verdict. 1. Do the actions of Carl Mitchell constitute malicious prosecution of Joy Wofford without probable cause? If your answer is yes, you have found in the favor of Joy Wofford and have determined by your verdict that Carl Mitchell is liable for the malicious prosecution of Joy Wofford. If your answer is no, you have found for Carl Mitchell and have determined by your verdict that the actions taken by Carl Mitchell were taken based upon a reasonable belief that Joy had committed a crime. Thank you, Mr. Santa Cruz. Just want to point out real quick that nowhere in that charge does it say anything about the terms of divorce papers or whether they have not been followed, or if we're litigating the terms of a divorce. We are litigating probable cause. That's what this case has been made about. Even though our defending counsel actually has a burden of proof to show that Officer Mitchell maliciously prosecuted Ms. Wofford without probable cause. And you're charged with the finding for malicious prosecution without probable cause, and there's two parts of that charge: malicious prosecution and without probable cause. And if you don't have one, you can't have the other. If you cannot find that Officer Mitchell acted without probable cause, you cannot say he maliciously prosecuted Joy Wofford. And there's simply not enough evidence presented from my opposing counsel to show that he did not act without probable cause. So let's break down real quickly what happened that day succinctly. Officer Carl Mitchell went to Joy Wofford's home to check on his daughter, Angela. And Joy Wofford told him that morning that she had a cold, asked her to keep for the weekend, even though it was his weekend to keep her. And during that visit, he testifies to having seen marijuana in the plaintiff's bathroom. And then he went to the police station, signed an affidavit for search warrant, ran it by 3 individuals. Why? Because he witnessed a crime. And like any police officer, he wanted to hold a criminal accountable and had probable cause to do so. And the opposing counsel has not, their burden today, proven otherwise. So I'm taking a few notes as this proceeding has gone on. And I want to first address a few things in terms of the evidence that they have provided today. First, I'm not going to say the phrase that has been repeated. I have the tally marks here 5 times. Nailed the. Let's think about that for a second. We have an officer who saw a crime committed, and he went to go report it with probable cause and said something that, he was excited to do his job, do what he's supposed to do, which is prevent crime from happening. And you can consider the fact, throw in the mix that his daughter was there where the crime was committed, if you want to look at that phrase a little more closely. I also want to point out that I believe if we're talking about the opposing counsel providing enough evidence, I think they actually provided evidence in the alternative. At one point on direct, Ms. Sanchez asked Detective Hayes if there would be an instance in which somebody could be glassy-eyed besides drinking alcohol. I wonder what that could be. What could be another instance? There was marijuana there, and she's glassy-eyed. And Detective Hayes just told you, there's a connection between what was there and the condition of her eyes, how she looked. Let's also talk about, again, what they've been making this about. Going to the apartment that day. Officer Mitchell went to that apartment that day. That is true. He admitted to it. And I'm not going to, not to mention the fact that Joy Walford, admitted to initially intentionally retaliating against him in that 24 hours that she gave. Officer Mitchell obviously could have considered that as a retaliation, another way to make him upset. And disregarding all that, though, we're not here, again, let me remind you, not here to litigate a marriage between an ex. We're not litigating the terms of a divorce paper. We're here to litigate if they had probable cause and if they proved it or not that our client acted with malicious intent and without probable cause. Another thing they mentioned throughout her closing arguments and really throughout the case is that Officer Mitchell is just an angry guy. And I think he would admit that, him and Joy Walford have had confrontations, and she actually admitted, I wrote it down, she said mutual aggression, mutual loathing was the actual words, mutual loathing, she said. And I can kind of disregard that because these two got married at a very young age. Joy Walford was in college. And the things that, if I were to be held accountable for the things that I've done when I was young and in love, I would not be here today. Let me tell you that. And on top of that, despite that mutual aggression and the anger that they say that Officer Mitchell acts on, he acts on his anger. But yet we heard from Detective Hayes that every time they've had encounters, he is professional. He has never, from what I've seen today, they've never provided anything on the record to say that he's violated or he has any blemishes on his record. They had opportunity. Detective Hayes was there. There was no prior history that Officer Mitchell has committed anything in anger in his line of duty, in a situation in line of duty where there are a lot of opportunities to overreact. If anything, that's a sign that Officer Mitchell is very good at his job. Nothing. And let's not also forget that, I'm gonna remind you, three people have passed this search warrant on. It went to Detective Hayes, to the chief, and then it was signed by the judge under oath. And in between that transition from Detective Hayes to the judge, the chief stopped on the way and told him, and looked him in the eye, I'm speculating there, told him, if you are lying to me, then you will never get a job in the city of Austin again, or the state, the entire state. And we're to expect that this man who's been professional his whole life and not displayed anger and has been working for 8 years would risk that after hearing that from his police chief, would risk doing that, would call a news team in, would plan ahead and call a news team in to be there for this event. And speaking of that, Channel 8 News, there are many people involved in this case. So I don't believe that there's been enough evidence by any means, any stretch of the imagination provided by opposing counsel to prove that they were contacted and were there for that particular purpose. And then there is a major allegation here made as well. And then is that Officer Mitchell planted that marijuana. And they suggest also, oh, Officer Mitchell says that there was 2-pound brick of marijuana. And in the period of time, that 2-pound brick became 19 grams. What we have established throughout this case, throughout this trial, that not only many witnesses have said the time and days that this has occurred, and Officer Mitchell left that apartment around 9 to 11, and Detective Hayes came in at 4:30. There's 6 hours there. 6 hours. And we also established that Officer Mitchell saw 3 people. And if you don't take his word at it, he saw 3 people in that apartment that day. If you don't want to take his word at it, Joy Walford couldn't tell us if they weren't there or not. On the day that she was arrested, she could not tell us if there were 3 people there or not. But Officer Mitchell swore here today on under oath that he did. So let's just imagine for a second, Officer Mitchell comes in, they have this confrontation, there's 3 people there, and maybe or maybe not, I'm making any allegations there, but maybe or maybe not, they planted that, they had that was their 2-pound brick of marijuana, and they see a officer leave. They're going to try to take that 2 brick and maybe left something behind. And then we've had some accusations here of jealousy. Jealous of what? Who? Brad Pitt? I mean, if Brad Pitt looks like anything like the real Brad Pitt, I kind of understand that to some degree. But again, enough to risk his job. He went through 3 people. He's been professional his entire career. The judge signed it. And on top of that, there was marijuana there. There was marijuana at the apartment that day. So once again, if you found Carl Mitchell's actions were based upon a reasonable belief that Joy Walford committed a crime, and you believe that opposing counsel did not prove beyond the preponderance of the evidence that Officer Mitchell pursued a search warrant without probable cause, you must write no. Officer Mitchell had probable cause to sign the affidavit for the search warrant. There's no foul play. There's no malicious intent. There's nothing of that nature. We've done our duty today by presenting the evidence of the case, and it was their requirement to prove that he had probable cause, did not have probable cause. Now it's time for you, the jury, to do your duty. Find that the defendant had probable cause to institute a search warrant against the plaintiff that led to an arrest. The facts demand it, and justice demands it. Thank you, Your Honor.
You're muted, Judge Miller.
Did you have, Ms. Rose, did you want rebuttal?
Yes, Your Honor, thank you.
Okay.
Did the actions of Carl Mitchell constitute malicious prosecution of Joy Walford without probable cause? If you decide yes, you have found in favor of Joy Walford and have determined that Carl Mitchell is liable for malicious prosecution without probable cause. Ms. Walford and Mr. Mitchell do have mutual loathing, but only one of them knows by heart just what it takes to meet a standard, get approval, and sit back while a reputation, a career, and a child's livelihood are tossed into chaos. We are here because of power. Power of a police officer to draw up a search warrant, power of a chief of police to approve it, and power of a judge to grant authority. All because one man carefully and meticulously set a plan in motion. The ultimate abuse of power is confidently saying, "Nail the bitch," as you turn over an affidavit and a search warrant. Power is about foresight. It's about anticipating moves and devising countermeasures, waiting for just the right moment, for just the right phone call. The aggressor plots one step ahead of the opposition and plays his trump card just after she has let down her guard. It's about making sure you surprise them and they don't surprise you. Jury, I ask you to consider one last time this power play. Would this entire saga of events have happened if Mr. Mitchell was not a police officer. Thank you.
Okay, thank you, counsel. Ladies and gentlemen, you've heard the evidence, you've heard closing arguments, and you have the charge. The case is now yours to deliberate. Bailiff Gibbons, would you take them back to the jury room?
Yes, Judge.
Okay. Very good. Very good. And we're supposed to do our deliberation, Judge Weems, or what do we do?
Yusuf, you tell us what you want us to do. Do you want us to go into a breakout room and deliberate, or just submit our score sheet? I have already submitted my score.
Yes. So the judges, if you haven't finished filling out the ballot, if you could just finish filling out the ballot before deliberating. Once all the judges finish submitting their ballots, then the judges can give feedback.
Okay.
It says I can submit another response. Can I vote more than once?
If you choose to, I will disregard them, unfortunately.
No, I am.
Alistair's got multiple personalities, and each one wants to vote.
This is not Louisiana. This is Texas.
I have received. Oh.
It's a Lone Star state.
Sorry, I was just going to let you know. Do you want the live stream to remain on during feedback, or should that be turned off now?
Yusuf, do you want the live stream to remain on? I think I've kept it on for the other tournaments, but it's up to you.
We can go ahead and leave them on just so that anyone who reviews this can hear the feedback as well. I have received all the ballots, so you can proceed with feedback now.
Mr. Dawson, do you want to go?
Mr. Dawson, why don't you go first?
Okay, I'm happy to. So let me begin by saying y'all are all awesome.
Tell them who you are.
Oh, my name's Alistair Dawson. I'm as I said at the beginning, I'm an old attorney at Beck. Redden. I've been trying cases now for almost 32 years. And I have got to try lots of cases. I will tell you this little story. So I was terrible at mock trial in law school. I went up against Al Odom, who's another great lawyer here in Houston, and he whooped me so bad that I went and did moot court for several years. I wasn't going to do mock trial anymore. And then ironically, I turned out to be a trial lawyer. So I will say this, the more of this that you can do, the better you'll get. The first time I had an oral argument in court, I was terrible. And I botched it and was just awful. And I could tell you horror stories, but the next time I botched it a little less badly as I botched it the first time. And the next time was even better. So the more of this you can do, the better off you'll be. And so I encourage you to keep taking as many mock trial, moot court, events and doing as many competitions as you can. I will also tell you, I teach trial ad, and oftentimes when I'm teaching trial ad, the students will say, well, our instructor told us the exact opposite of what you're saying. So if I say something that's in conflict with what Judge Weems has told you, you go with what Judge Weems has told you and just ignore me. I thought y'all were all awesome, really, really talented. And I think you all have great futures ahead of you, and the bar will welcome you when you get through law school. I think it's hard to do it in a Zoom format, but y'all handled it very, very well. I guess I don't know how much detail you want, Judge Weems. I would say sort of for everybody, I think it's important on both sides to identify the themes of your case and say, okay, on the plaintiff's side, we have to show malice and we have to show whatever, no probable cause or not reasonable suspicion, and sort of figure out what your 2 or 3 main themes are, and then get your evidence lined up with those themes. Why was he mad? Why did, when he uses the terminology that he uses, that's indication that he's mad. When he calls the TV station, that's an indication that he's mad. So you move all your evidence into whatever theme it applies to. And so I would say, I do this quite often. I learned this from David Beck. He'll start a trial. He'll say, ladies and gentlemen of the jury, as you hear the evidence in this case, there are 4 points I want you to consider. And he'll put point 1, 2, 3, and 4. And then he'll show the evidence that relates to each of those 4 points. And then when he gets to closing, he re-urges the same points. He'll say, remember, I told you at the beginning of this case, there were 4 points. Now let's review the evidence that you heard. I told you that the evidence would show that there was malice. Okay, let's look at the evidence of malice. There's this piece of evidence and that piece of evidence. Let's look at the evidence of lack of suspicion or lack of probable cause. So fit all your evidence, figure out what themes you've got and fit your evidence into those themes. So that would be one major point. I would encourage you not to read. One of the things I tell young lawyers when they work at our firm is the mistakes I see is young lawyers, they'll do an outline for a deposition, or they'll do an outline for a cross-examination. And it's like their Linus blanket. Now y'all may be too young to even know what a Linus blanket is, but they don't want to get rid of the Linus blanket. And I remember one time when I was teaching trial ad, there was a young lady in the class, and I went and took her notes from her. And this was all videotaped. And I said, do this cross without your notes. And she was way better without her notes. Because a lot of times when you're wed to your outline, particularly when there's a witness examining, you're not listening to what they're saying, and you get these little nuggets. And I'll go through and point out some of the nuggets that I heard during the course of the day. And if you're listening, you can follow up on the nuggets. But if you're reading your next question, you're not listening to what the witness is saying. So I would say, don't read as much. Have notes about what points you want to make, but try not to read it. And listen to what the witness is saying. And then another major point would be simplify. Make it simple. There were a lot of questions that were kind of a little bit long and a little bit convoluted. Break it down and make it simpler. And then how much detail do you want me to give, Judge Williams? I wrote lots of notes, but.
So also they're not, here's the thing, like case specific stuff, you probably don't really need to give them a whole lot of detail on because they're never going to try this case again. This is the final round, but feedback that they may be able to take on with them for the future, like stylistic things, like if you have any individual stylistic tips for any of the individual advocates, those kind of things would be helpful. But like, don't go into the merits of the case because this case is done for them.
Got it. So Ms. Sanchez, your opening, you have you're very well spoken, very great command, very, I liked your presentation. I liked your tone. I liked your pace. I think that you, and this is true for probably all of you, you want to tell a story. A trial is about telling a story. There's Jim Purdue Sr. That's what he preaches about is that great trial lawyers are great storytellers. And so, for example, just on the open, and I don't want to get into specifics, but this is a case about a poor single mother who was sitting at home, and her ex-husband comes over. He's mad at her. He's mad because he has to make these alimony payments or whatever he's mad about, or mad about the boyfriend or whatever. And so you want to tell a story. And she's sitting there. He comes in. She's trying to be nice. He goes to the bathroom. And then she gets arrested. But it gets to, so tell your story. Fit the facts into the story that you want to tell, if that makes any sense. And then, I wrote all these notes. Oh, so here's the thing. So there were lots of missed objections. There was a whole bunch of hearsay that came in that whenever you hear what did so and so tell you, that's when the hearsay antenna goes up. There was also lots of, and I don't know, maybe y'all haven't had evidence, so it's probably not fair. But a witness has to have a foundation before he or she can testify to certain things. And so there were lots of examples where witnesses didn't have a foundation was not laid. And you'll learn more about that when you get to evidence. So I don't want to spend too much time on it, but so I'll just say that focus on hearsay and focus on whether foundations have been laid. And then on crosses need to be very tight. They almost, some people say you don't ask questions that you don't know the answer to. I don't think that that's right. But it needs to be very tight where there's no room for the witness to wiggle. Isn't it true this? You would agree with this. You've previously said this. So it's very focused, laser focused. And one of the things, I think Ms. Sanchez, you had a difficult witness, as I remember. And this is what I do. I'm not saying everyone should do it, but I always say, no, sir, that wasn't my question. Let me ask my question again. And then, so I make it kind of on me. And I think juries sort of like that as opposed to bantering or badgering with the witness. So I always say, no, sir, I'm sorry, that wasn't my question here. And I'll do it 2 or 3 times. And then if they're still not cooperating, then I ask the judge for help. I will say this: when you go to ask the judge for help, you better make sure the judge grants your non-responsive objection, because then the judge is telling the jury this witness is not cooperating and not behaving as he or she should. So I always wait until I'm fairly confident that the judge has probably had enough, and then I'll make my objection non-responsive. And that's the legal, again, when you get evidence, you'll learn this, but the objection is objection non-responsive, and that's all you have to say, and the judge will usually grant it, and then he or she will say whatever they want to say to the witness. And that the great thing about that is the jury hears that. So tactically, it's a good thing to do. I'll get through this, and then I'll let the experts see. When you're in the presence of Hall of Famers like Judge Weems and Judge Miller, you get out of the way as quick as possible. So I'm going to get out of the way. I think, here's another thing. So motions in limine. Motions in limine, all that means, and one of y'all did this, I forget whom, and I'm sorry, but one of y'all approached on a motion in limine. I think it was Miss
It was me, Your Honor.
Yeah, it was you. You jumped up when you saw something coming about a boyfriend or something. That was good, and you did really well with that. You saw it coming, and I actually think you got up there before the testimony came in, but I could see it was coming. So, but you did a really good job. So, a motion in limine, it doesn't mean that you can't present the evidence. It just means that you have to approach the bench before you try and introduce it. And a lot of people think that, oh, well, that's been excluded. No. It just means you can't talk about it to the jury or present it to the jury without approaching the bench. So if you lay a predicate or you lay the foundation, and then you say, Judge, I'd like to go, you ruled on this on the motion in limine, I'd like to go into it, and here's why I think I'm entitled to it. And then conversely, if a motion in limine is granted, or even if the court says, no, you can't do it, then you have to make an offer of proof. And I don't know if y'all covered that in your trial or not, but that's a complicated thing where you basically put the evidence on outside the presence of the jury so that it's in the record. so that the appellate court can take a look at it. With that, I've said way more than I should have, and I'm going to turn it over to Judge Weems and Judge Miller. Thank you for letting me think that y'all were awesome. Keep going. You got great futures ahead of you.
And in case y'all didn't know, Alistair Dawson is a partner over at Beck Redden, who sponsored the tournament. So thank you so much to you and your firm, Alistair, for sponsoring the tournament this year.
And former chair of the Houston Bar Association and everything. So
current president of ABOTA, American Board of Trial Advocates. I mean, he's got a pretty lengthy resume himself that he's being modest about. But Judge Miller, why don't you go next?
Well, I don't have much to say. I think it was great. You all were very good, and you had a very difficult judge, so you handled him well. I'm mostly easygoing for the most part.
Tell them who you are.
I don't know. I'm Bo Miller. I'm judge of the 190th Civil District Court here in Harris County. But happy to be the visiting judge in Lone Star State. Let me think. Yeah, so your evidence issues, I mean, Alistair's right. And I at one point tried to probe you to figure out, do you have the right objection, and you didn't. I think that was kind of a prejudicial issue, right? So always say prejudicial, right? It's going to prejudice my client. That's an easy go-to, right? And just be like, yeah, talking about the lie detector test when it's not really relevant is probably prejudicial. So that's kind of where I was going for that. I think the plaintiff counsel tend to be a little aggressive in presenting your case, which which is good in parts, but maybe too aggressive, and so you lose sight of the overall objective. Maybe I think that was maybe what Mr. Dawson was also talking about. And going back on both sides, going back to opening statements, which is what the evidence will show. There's a lot of argument that you put in there, and when you do that, I think for a jury, for a judge who doesn't really know the case, you get lost in it, right? And the opening statements, you want to flag what are the important issues, what the important facts are, and how they build your narrative, like what Alistair was saying, to get to the jury to understand what your case is about, so that when you put it on, then you can have your closing arguments to tell you why they need to do the way that they need to vote in the jury. And same thing with I'll go to the closing arguments. I thought that Mr. O'Leary, when you put the verdict up, the question up, was really good. That was very, very good, and talk about that and talk what the evidence is. And that's we see that a lot, where you want to use the you use verdict to show how the jury needs to get where it needs to go, and how to answer that question your way. Mr. Santa Cruz, sorry, I kept calling you Mr. Cruz, but Mr. Santa Cruz, I would highly suggest you never move for a directed verdict after the close of evidence when the judge has denied it at the close of the plaintiff's case. Because if I didn't grant it before that, I'm not going to grant it again. So I was like, okay. But you can try it, but I don't know if any judge will like it as much as I didn't like it. So I don't know who told you to do that, if you're taught to do that or not, but I dare say my colleagues and I on the bench will entertain it as fast as I did, which was not very fast. Let me think. I think the really figure out the nuts and bolts of like what I think Mr. Dawson was saying, what the important fact issues are. I think Ms. Sanchez, you got really into the weeds of things you didn't need to get into, which lost stuff, right? Talking about his bladder and peeing and things. I can understand kind of why you want to do that. And we're trying to go to it, but it's not going to land, right? And you have to be very careful, especially crossing a witness. What's going to land and what's going to make you look stupid. I'm not saying you look stupid, but it can happen. It can happen a lot if you don't if you ask those questions, you go down that road. And you didn't need to go down those roads, by the way, right? I think, but we all have done that before. But no, I thought you guys are great. I think for 1Ls, right? Yeah, exceptional. And there's a lot of room for improvement, but we're on live stream, but we see a lot of lawyers, and you'll be just great. So I'll leave it with that. But congratulations again this far, and thanks for dealing with a difficult judge like me.
Thank you, Your Honor.
All right. Hi, I am, well, or Yusuf, do you just want to announce? Yusuf popped up.
No, you can go, Judge Reed.
I'll try to
Sorry
be-
about that.
No, it's all right. I try not to take too long. I'm Judge Christine Weems. I'm just sitting judge of the 281st. I'm also director of interscholastic mock trial at University of Houston, where you guys are. So assuming that you guys want to really do this, had a lot of fun. I hope you did. I hope to see you guys at tryouts at the end of the semester, because then you'll be dealing with me. I'm going to try to keep it pretty short. Because I don't want to repeat. I mean, I concur with everything that Judge Miller said and Alistair, Mr. Dawson said with regards to storytelling. It's real important. And advice I always give all my advocates is this: you live with a problem for so long that you lose sight of the best way to tell the story because everything starts being important. Always consider this, and this is how I look at it. If you were to grab a friend and take him to a bar and buy him a beer, what would you tell him about your story? How would you package it? All right, because that's what you got to do. You got to package it for people who don't know anything about the problem. All right, like I pulled the problem for Yusuf and I went through and I changed it. You might have seen it was a 2002 case. I had to go through and change all the years, and even all the work I did on putting together the problem, I still am not 100% sure about the problem, like what happened. And I think a lot of that is because you need to tell a very linear story. And I just think for the future, just be mindful of that. Anytime you're trying a case to a jury, they know nothing. They know absolutely nothing. And so like that was kind of some of the issues when Alistair was talking about how Mr. Dawson was talking about how you package the story. It's because you got to package it in a story that in a way that we can follow you. It's like when you come out of the gun with a really combative statement, we don't know why that's important yet because nobody has an idea of what the story's about. So it's like, ooh, it's big and inflammatory, but I don't know why it matters yet.
And don't assume the judge does either, by the way. They may not know very much about the case at all.
Yeah.
Sorry, Judge Reeves.
No, but it's very, very true. So just be really mindful that a lot of times your audience doesn't know. So particularly your jury doesn't know anything. So always package it in a way it's like, all right, how am I going to explain this? It's kind of like the same things with your directs and crosses. I think my biggest issue with all y'all, it's just you don't know yet, and that's fine, is organization. That's a lot of the biggest issue with what I had with most of you is just the organization of your stuff. We're in mock trial, we teach the concept of blocks. Blocks are just points. They're like little squares. One way you could physically see it is if each block was on a postcard, like a note card, and you could write your block there. And then the next block is on a different note card. And if you needed to, you could switch all of your blocks around, but it would still make sense. That's the best way to organize crosses. Same thing with directs, that way we can just follow everything easier. And again, everything is all about presentation to strangers. What's the best way to follow it easier? I know you guys don't know evidence yet. I do appreciate that you can see it in your eyes. It's like, I know that that's not right. You know what? At this stage, and this is what we tell them in mock trial right now, just pop up and object. Say anything. Dude, I had one of my advocates the other day just like, yeah, that just didn't feel right, Judge. I'm like, okay, well, what's the legal objection behind that? And yeah, she didn't really know what it was, but we talked her through it. It's like, okay, well, explain to us what doesn't feel right about it. And then we finally got around to what she was saying. It was a foundational issue. When you don't know, just talk it through. It's like, objection. What's your objection? Well, I don't think that what she said may be reliable because blah, blah, blah. At least we start going, okay, they don't know evidence yet, but they are recognizing that there's a problem here. And for us, when we're evaluating you, we're like, okay, that's a good place to start. Because when we don't see, like what Alistair was saying, that, there were a lot of misobjections. I couldn't tell if you missed it because you didn't know, like you just don't know, that you don't know hearsay, or you knew that something was wrong, but you didn't know to call it hearsay. So don't be afraid just to object to something and just talk your way through it. And if we can figure out, we sometimes a speaking objection is better than no objection at all. So at least it shows us your instinct. Like, okay, we get it. They've got this instinct here that this should not come in for, it's either prejudicial, it's irrelevant, it's something. But at least we can see it and, see it more than just in your eyes. I can see in your eyes, it's like, oh, I want to do something, but I don't think I can right now. It's like, oh, they missed the opportunity. It's all right. So that's just some food for thought in that regard. And then I'm trying to be real general here, because I know in the reality of it, y'all just want to know who won. I get it. Always, when I break down a mock trial problem, and this is just for future reference, I always like to start with the closing. And the reason why I start with the closing is this. Start with a jury charge, and I appreciated that, Mr. O'Leary. Not all problems give you a jury charge, but they give you a jury charge. You should always use it, because that's how you know what you need to prove. The reason why I like to start with the closing is because the closing is the evidence you have to get in to prove your side, right? So you start with the closing, and if you know what you got to prove in your closing, then you know what you got to get out in your crosses and your directs, right? And then once you have your closing nailed down, your opening is basically your closing, just less argumentative, with a whole lot of the evidence is going to show this is what you're going to hear. So food for thought later. If you're ever doing Hippard again, you don't have coaches and you're trying to do it on your own, my suggestion is you start with your closing. Understand what you have to prove. And that way you know that in your directs and crosses that you have gotten out those points that you need to prove. And then if you get in some extra stuff like, credibility, motive, bias, all that fun stuff, you get it in, but at least you make sure that you've gotten in, you've ticked all the boxes. We have to prove nothing else gets in. These are the parts that have to get in, or we cannot make our case. All right. But for 1Ls, y'all did a great job. It was Yusuf and advocates, thank you so much for having myself, Judge Miller, and Mr. Dawson judge the finals. It was great to see you all in action. And sincerely, I hope all of you will consider trying out for the mock trial team. We'll have tryouts later on this year, probably in April or May.
I just want to say thank you again to all the judges, and especially thank you to Judge Weems. She helped find a lot of the judges that judged you and gave you feedback throughout the tournament today. So I'm sure the competitors were really appreciative of that. I know I definitely made my job a lot easier. So we do have the results now. I'll go ahead and announce the best speaker first. So the best speaker for the 2021 Hippard Novice, sponsored by Beck Redden, is Miss Rose.
Thank you, everybody. I really appreciate that. That means a lot, because this has been terrifying. So to those listening out there, you can do it too.
And for the actual results, it was very, very close. Once again, the theme for this tournament, a ballot was won by a single point. A second ballot was won by 2 points. It was very close all the way down to the end. But Team 1 is the winner of the 2021 Hippard Novice competition. Congratulations to Team 1. If you could all stay on for a second. I know Chelsea Klump wanted to take some pictures. We're going to do a photo with the judges and the winners, as well as the judges and the runner-ups. So if Chelsea is there, yes. I think she'll take
first let's do one just with this crew who's on the screen right now, including you, Yusuf, who, by the way, round of applause to Yusuf for putting on this competition. Mock trial over Zoom is really difficult, getting all of the judges, all of the problems that come up with Zoom and the climate that we're living in right now. And he did so much of this all by himself. And so he deserves a lot of praise for putting on such a great competition for you guys. Okie dokie. So I'm going to take the first screenshot here. So everyone will look at their webcam and give a nice big smile. Okie dokie. Okay, that's screenshot number 1. Okay, now let's do one with the winners and with the judges.
Do you want me to kill the live stream?
No, this is fine. This is fine.
Okay.
Future generations can look forward to having their moments, getting their screenshots taken. So that's fine. Oh. Okay. All righty. And everyone, nice big smile. Okay. All right, perfect. Now let's get Miss Rose and Miss Sanchez back on. Let's get a picture of you two ladies with our judges. And Mr. Leary, if you wouldn't mind turning off your camera for a second. Okie dokie. Webcam and smile. All right, great. Now let's get all of our competitors. Thank you, judges.
Team 6, excellent job. I hope to see you guys in the fall when we're back in person.
Absolutely. I'm so
Yes.
very impressed. Congratulations.
Congratulations. It was awesome to work with you.
Oh, you guys too. That was brilliant.
You guys were great and super respectful. We appreciate it a lot.
All right, love that good sportsmanship. Now let's smile. Okie dokie. And then just one of our two winners, Miss Sanchez and Miss Rose. Okay, and smile. All right, well, thanks, y'all. Those are all of the screenshots we need. Again, we appreciate everyone putting in all of the work to our competitors. I know that, mock trial it's a lot of work. It's really intense. It's very difficult, a lot of preparation, but all of your hard work definitely showed. And, you guys are only going to continue to get better and better from here. This is just the start. Thank you to the judges for, giving your time and feedback. And again, to Yusuf for putting on a great show, a great competition, a great experience for everybody.
Thank you
Yeah.
a lot. Sorry we messed and emailed you so much.
No, you're good. You're good. And with that, Judge Weems, now you can kill the live feed. Unless Judge Weems has left.